7. Total 7. 6. ಸ್ವಲ್ಪ
7 DP and DP.
ಹೆಂಗಾದ್ರೂ ಎಷ್ಟು ಕೊಡೋದಾದ್ರೆ ಕೊಡ್ತೀನಿ ನಾನು. ಕೋರ್ಟಿಗೆ ಬನ್ನಿ 7 ಬನ್ನಿ ಜಡ್ಜ್ ಬಂದ್ರು.
Or one fresh matter, my lord, for preliminary hearing tomorrow.
One matter, special MLA MP court matter, special MLA MP court matter. One matter, 2:30. The reason is I'm no way connected in the matter.
Maybe
I've been made as an
Tomorrow.
My lord, this is a land acquisition matter. The petitioner is a super senior citizen and
Give it, we'll fix it.
Lords,
requesting for urgent listing, my lord.
Give it.
this is regarding those National Highways matter minutes 28 extension. Lords, I had given the memo yesterday. It was not posted. If it can be taken up 2:30 minutes, I have informed the National Highway advocate to appear at 2:30. Requested him, Lords. Your Lordships have passed the order. Similar
Let the draft be ready also. Huh? I've dictated.
draft of the order, my Lords.
So you give the memo. As soon as it's ready, I'll have it and say same.
Very well.
Put it in. We'll inform you.
Very well. I will follow up, my Lords.
Draft ready.
I'm obliged.
The 2024 pending DDA matters,
Give it.
some urgency, so kindly give any dates.
Yes.
Mention. My lord, serial number 3.
List 1, page number 1, serial number 1 to 5.
3, my lord. My lord, serial number 3, arguing counsel is unwell, 2 weeks accommodation. I have informed the
List 1,
KDB, list 1.
No.
tax matters.
List 1 is tax matters.
Yes, next.
Page number 2, serial number 6 to 15. Page number 3, 16 to 24. Page number 4, 25 to 31.
29, your lordship.
29.
29. I pray for short adjournment. I'm not keeping well.
Page 29 is a matter which was listed last week also.
Because I'm not keeping well.
Stop, I am not, advocate is not well because I am not opposed. It's come up on 3-4 occasions. It's a matter where you have to file an appeal before the first appellate authority. Well considered order, no violation of principles of natural justice.
It's the matter of
Number 5, 32 to 38. Page number 6,
36 and 37, my lord.
37.
It's short accommodations requirement. 36 and 37. Sorry, 37 and 38. 37 and 38. 15 days time. Sir.
38 can be disposed of. They have challenged the order of rectification. First appellate authority has dismissed the appeal on the ground of limitation. Here, my lords, according to the petitioner, the limitation had to be calculated from the date of receipt of the rectification order. That has not been done by the first appellate authority. My lords could ask them to calculate it from the date of rectification order and matter can be sent back to the first appellate authority.
Yes, it can be done.
Then you wait, let us see.
Okay.
Page number 6, 39 to 42. Page number 7, 43 to 46.
My lord, 45, my lord.
45.
I have informed the other side, my lord. Kindly have it next week, my lord. We need to produce some judgments. Already we have informed the other side, my lord.
That's okay.
Next week, my lord.
2018 matters, you ask time like this, what happened?
Just 1 week, my lordship will.
Just
21st.
Please, my lord.
Page number 8, 46 to 49. Page number 9, 50 to 54. Serial number 48 to 48. Before responded to
inform the other side.
Yes.
That request to be disturbed.
Serial number 54, my lords. I was responding. Kindly adjourn it for 4 weeks. The opposite counsel.
54, I appear for petition, my lord. Senior is also online. Rohan Shah.
Please, my lord.
For time, sir.
My lords, 4 weeks time to file statement of objections.
Interim order, may kindly.
My lord, the interim orders to continue, please.
The request of the respondent, revenue,
Please, my lords. I appear for
that
Madhu
is
as well.
adjourned. Just after 4 weeks, date put in. Interim order and obligation extended to the next date. It's made clear that the respondent is to complete the pleadings positively by the next date.
17th. Page number 10.
Grateful. My lord, the next date is
17th of February.
Grateful.
Page number 10, 55 to 59. Page number 11, 60 to 63. Page number 12, 64 to 65. Page number 13, 66 to 70. Page number 14, 71 to 74. Page number 15, 75 to 80. Page number 16, 81 to 83. Page number 17, 84 to 89.
My lords, 86, my lords. My lords, is an pertaining to nice, my lords.
Not before me list, before
Next
appropriate
week, my
bench
lords.
after obtaining orders in the next week.
Next week, any date, my lord.
21st. Page number 18, 90 to 95.
Lords, 90 also same, my lord.
90, same order.
21st, my lord. Much of.
Page number 19, 96 to 98. List 2, page number 1, 1 to 3.
My lords, serial number 2, my lords. There's some urgency. Can it be taken up at 2:30, my lords? It was a matter which was moved for end of the list yesterday.
What is urgency?
My lords, it is before KIDB today for the orders, my lords.
You ask the KDB council to be present.
Please, my lords.
We'll take it up after the 20th, after the 25th matter, we'll take it up.
Obliged.
Hello, serial number 1, serial 1, man.
Just wait.
Arjun.
Fresh matter serial number 1, Mahesh Kumar R.
Sure. After the petition, my lord, due to a throat infection, I had adjournment, my lord.
You wanted some other.
Adjournment, yes, my lord.
At request.
This is the same matter where recovery proceedings are challenged.
Recovery proceedings
Without
is
challenge
merits,
to-
my lord. There is merits in the case.
Copy no kotti last. Request
No, I'll
for-
just serve the copies, my lord.
Don't strain your throat.
ಮುಂದೆ ಆಚೆ ಕಡೆ ಸಿಗ್ದೋಗು ಕೇಳ್ದೆ ಕಾಫಿ ಕೊಡಿ ಅಂತ.
I'll just please do it, sir.
Relist on.
27th.
Much more.
Serial number 2, Bhargavi SV.
Appearing for the petitioner, my lord. My lord, this is the matter under KGST Act, my lord. The petitioner is carrying out the business of retailership, my lord. And for the period 2019 and 20, the petitioner had filed his returns, my lord. And respondent authority has issued assessment proceedings and passed ex parte order, my lord, without serving the show cause notice on the petitioner, my lord.
Fact for one assessment here, my lords, the other day, also pleased to remind the matter, levying certain, I think cost was levied also.
In the portal, notice in the portal, you didn't see what
My
is
lord,
it?
petitioner is uneducated, my lord. He is not aware about using the Gmail. For 5 to 6 for financial periods, my lord, same order has been passed, my lord.
But you're earning very, very well. You have to be careful, madam. When you're earning so much, you must have somebody to look after all this. Where is the observation made? No statement. 5.
It's page number 30, my lord. Last second paragraph. As per rule 142, 1A of CGST rules 2017,
Page?
30, my lord.
Yes.
The proper officer is required to communicate the details of any tax, interest and penalty as ascertained by the said officer. Hence, as per the provisions of section 73, subsection 1 of CGST Act, the show cause notice in DRC 1 as mentioned in table 1 and also served to the taxable person through his office mail to the registered email ID of the taxable person. In the said show cause notice, the taxable person was called upon to file objections, if any, to the proposals of levy of tax, interest and penalty within 30 days of the service of notice.
Email ID they have sent. How else must they serve? The petitioner has called in question the correctness of the order. Adjudication order for the period 2019-20, copy of which is enclosed at annexure C and C1. It is the case of the petitioner that order of adjudication passed under section 73(9), read with section 75, comma section 122, section 50 of the KGST Act 2017, read with rule 142 of KGST tax rules. Was an order that was passed ex parte. Submitted that the notices were not served. It was further submitted that though notice is stated to have been sent through email to the email ID of the petitioner, however, petitioner is not familiar with the electronic communication and accordingly not being aware of the show cause notice has not replied to the same. Further submitted that the court may take note of the bona fide lapse, comma, set aside the order of adjudication and remand the matter for adjudication afresh for reserving liberty to the petitioner to file reply to the show cause notice. There is the order of adjudication dated 29/8/2024. That AGA upon instruction submits that notice has been issued to the to the registered email ID, which details are available in the GST registration documents, and it is the burden of the taxpayer to have taken appropriate steps to make out reply. Next. Taking note that the order of adjudication is passed without any reply of the petitioner, it would be appropriate to afford an opportunity to the petitioner to make out his reply to the show cause notice, which would meet the ends of justice. Accordingly, taking note that the impugned order of adjudication at Annexure C is an order that is passed ex parte. In light of the discussion made above, it would be appropriate to set aside the order at Annexure C and remit the matter to the stage of reply to show cause notice. The reply to the show cause notice to be made within a period of 2 weeks from today. Petitioner to be present before respondent number, before the second respondent. For the second respondent, along with reply to the show cause notice on 28th of January at 11:30 AM. Needless to state, if the petitioner does not avail of the opportunity by marking presence on the date fixed, petitioner, the relief extended to the petitioner of reopening the proceedings would stand recalled. In light of the lapse of the petitioner to pay sum of rupees 10,000 to the High Court Legal Services Authority. All contingencies are kept open. PG accepts notice for the respondent.
My lord, serial number 34. Same issue, my lord, same assessee for different tax period.
Please don't make it a habit, madam. I am not like others. I'm making it clear.
Please, my lord.
I'm not going to blindly do this just like that. Some people will say, no, just like that, same order. I'm not going to do that. You have to show your diligence. Now I have to say same order. Any change? Same.
Dates might change, my lords. Adjudication order is dated 27/1/2025, Annexure C. Annexure C. Order dated 27/1/2025.
That one change, impugned order. The rest of
It's
it will-
passing separate orders in all three petitions.
Correct, correct, separate.
In serial number 2, the name of HCGP may be recorded.
See, number 2 only, HCGP, except
3 and 4, my lords, I'll appear, AGA.
3 and 4, EGA, impugned orders matra change. Manjuna.
Yes. Serial number 4, Bhargavi.
Same. 4,
Same assessee, different assessment.
Different assessment.
5, serial number 5.
Petitioners, kindly pass on. Kindly pass on.
Pass over.
Much obliged.
Six, serial number 6.
Lordship, challenge, income tax matter, Lordship. Challenge is to the penalty order. The challenge to the assessment order is already pending before this court. Stay has been granted, Lordship.
Income tax. Who's there?
Sanmati.
Income tax.
I'll just pass over, let him come. I'll take it up. Pass over, as soon as he comes, I'll take it up.
Obliged.
After the fresh matters, 25th matter, I'll again take up these matters.
Obliged.
Just find out where they are.
Please.
Sure.
7. Serial number 8.
Pass over.
9.
Your Honor, this is a writ petition challenging the cancellation of GST registration. In this, Your Honors, they have given a show cause notice. The show cause notice was vague, Your Honors. The show cause notice is at page number 24, Your Honors.
9. Six, 7, 8.
Yes.
Your Honors, in the show cause notice, they state that Rule 21E, person avails ITC in violation of provisions of Section 16 of the Act or the rules made thereunder. And he gives me 7 days time to submit. This show cause notice is vague. I have given a submission dated at Annexure D, dated 4/11/2025.
Yes,
I state that, Your Honor, this is a central tax, Your Honors.
Central tax.
Central.
Where nobody is there, central government today. I'll pass over, let them come, I'll take it up.
Your Honors, you may issue notice, Your Honors. Let it come up at next week, Your Honors, next Tuesday.
Without the presence of the other side, I won't do it because next date same thing will repeat. I'll pass over, we'll see, they'll come. I'll take it up
Okay, Your Honors.
immediately after the 25th matter. Pass.
Much obliged, Your Honors.
10. Serial number 10.
They don't have a bench today, no? Benches.
There are some matters listed before. Earlier, rosterally, some matters were given.
Pass over and then take it.
Please. And some matters, two, 3 matters are listed before court, all one also, a batch matter.
My lord, this is a GST matter. Serial number 10, my lord. Wherein my input tax rate has been blocked, creating a negative balance by invoking Rule 86A.
The state
Sir.
appears here, is it?
State, yes, my lord.
Yes.
My lord, if I may briefly narrate the facts, my lord.
So let you take out notice.
Yes.
You have not sought for any interim relief.
No,
There
my
is no
lord.
interim.
No interim
So
relief.
let them take the step.
I'll accept it also.
Any short date, my lord.
AG accepts notice for the respondents. It's a small issue, is it?
Yes, my lord, small issue. We
They're
can-
saying it's a small issue, is it so?
Please, may be called on 27th or 28th month.
It's a,
Next 3 days or holidays, so I'll not be able to.
it's a narrow issue, is it?
My lords, it's with regard to the blocking of input tax credit. There's already a judgment of this honorable court which has been affirmed by the apex court, saying that you can't do it straight away. They have to give a notice of hearing, stating certain reasons as to why you want to block. I'll just verify if that has been done.
AG accepts notice for the respondent list matter. In the preliminary hearing list on
27,
28th, my lord.
28,
28th.
11, Prashant, yes. Eleven.
Please, my lords. I request 11 may be taken up with serial number 65 as well, my lords.
You have to take.
11 along with serial number 65.
No, I'll pass over. Pass
The
over.
issue is covered.
Pass over.
12. Annamalai, yes.
Appearing for the petition. Lord, in this case, my lord, challenged the so-called notice DRC-01 as well the order in original DRC-07, my lord. The so-called notice issued itself is in violation of principles of natural justice, my lord. Please see DRC-01A for a moment, my lord, which is at page number 130, my lord. It was issued on 6/9/2025, my lord. Then, my lord, at page number 166, my lord. 166, last but one paragraph, my lord. You are advised to pay the tax amount along with the interest full by within 10 days, failing which so-called notice will be issued. 10 days time has been granted, my lord, before issuing so-called notice. This is dated 6/9. So effectively till 16/9/2025, the time was granted by the authority, my lord. Otherwise, we will issue the so-called notice, my lord. Then below that, my lord, in case you wish to file any submission against the above ascertainment, the same may be furnished by 10/9. They are given some 3 days time, my lord. That is not a reasonable time, my lord. That is number one. Before that, they are given 10 days time, failing which so-called notice will be issued, my lord. Please see, so-called notice was issued on at page number 90, my lord. On 10/9/2025, so-called notice was issued, my lord. The granted time 10 days, my lord, till 16/9. However, before that only on 10/9 itself, the so-called notice was issued, my lord. This is one of the ground, my lord. There are multiple grounds are there, my lord. This is one of the ground that there is a violation of principles of natural justice where the time granted up to 16/9, 10 days time was granted. However, within 4 days only, the so-called notice also have been issued. On the short ground, the matter can be remanded back at the stage of filing reply to DRC-01A, my lord. Then the proceeding can be continued, my lord. This is one of the ground, my lord.
My lord, I will take notice, my lord. Next week,
So you find out.
I will seek instruction.
HCGP accepts notice for the respondent.
Because there is a limitation issue, my lord, for us. We will give reasonable time. If they say it is not a reasonable time, means according to their whims and fancy, we can't
Correct, madam, but that's,
complete.
That's your headache.
Yes, ma'am.
That's not his headache.
Yes, ma'am.
If you allow it to go till the last week, whether he's interested or not, both are at fault. I don't want to blame
No,
anybody.
my lord, what happened due to limitation?
That is your headache, isn't it?
Yes, ma'am. Yes.
So I'm saying, no doubt they would have contributed.
Yes, ma'am.
But it's a, so if you
No,
have to,
I'm not against remanding back, my lord, but subject to cost, my lord, actually, because 2 crore demand is there.
but cost to legal services.
Reasonable cost.
So we'll remand it.
Yes, my lord. I have produced one judgment also, my lord, where heavy demand is there. So reasonable, because they are also at default. Let them serve to legal service authority. That's all, my lord. Due to this relief from this honorable court, it's my request. That's all, my lord.
Yes, yes. The Annamala is reasonable. The petitioner has. I'll be little more reasonable.
My lord, that judgment is very reasonable, my lord. Very, very reasonable, reduced.
Wait, I'll come to that later.
Yes, my lord.
The petitioner has called in question the order of validity of the order of adjudication passed under section 73(9) of the GST Act dated 5/12/2025 for the period of April 2021 to March 2022. It's the case of the petitioner that Form GST DRC 01A, which is an intimation of tax ascertained, came to be issued on 6/9/2025, providing an opportunity of 10 days to pay the tax amount along with interest, failing which show cause notice would be issued under 73(1) of the CGST/SGST Act 2017. It was further provided that the SSC could file any submissions against the above ascertainment. Meanwhile, the Form GST DRC 01A came to be issued on 6/9/2025, and even before the lapse of 10 days as stipulated therein, show cause notice came to be issued in Form GST DRC 01.
Yes, madam.
On 10/9/2025 within the period of 10 days prescribed. Full stop. Accordingly, it is submitted that the adjudication order passed pursuant to the notice at Annexure B1 is in violation of principles of natural justice, and same requires to be set aside and matter remanded for fresh consideration to the stage of reply to GST DRC 01A.
Please, madam.
And HCGP submits that the urgency shown to complete the proceedings is in light of the statutory limitation, and the petitioner was in fact responsible for prolonging the matter till such stage. Next. Without entering into merits of the contentions as to who was responsible for matter being concluded hurriedly, taking note of the time that was stipulated to make out reply as regards Form GST DRC 01A, it would meet the ends of justice by setting aside the adjudication order at Annexure
A1, my lord.
Annexure A1, as well as the notice in Form GST DRC 01 at Annexure B1.
Yes, my lord.
And
No, annexure DRC 01 is B2. So cause notice is B1, my lord.
No.
Matter is maybe remitted back.
A1, A2, B1, B2 required to be quashed, my lord.
No, that's what I've seen.
Yes, my lord.
B1 is also set aside. Matter is remitted to the stage of reply to be made out to the show cause notice in
No, my lord.
Form
Reply to DRC 01A, my lord.
That's what I'm saying.
Annexure C, my lord.
That's what I'm saying. Reply to the show cause notice in Form GST DRC 01A. 01A.
That is not so cause notice, my lord. Only notice, my lord. Pre-consultation notice.
Reply to the pre-consultation notice in Form GST DRC 01A.
Yes, my lord.
Good stuff. Such reply to be filed within a period of
4 weeks, my lord.
4 weeks from date of receipt of certified copy of the order.
And in that context, my lord, liberty may be granted in favor of the respondent to pass the appropriate order.
Upon
Without,
such
No, thereafter they have to give so cause notice, my lord.
upon such reply being filed, needless to state, the authorities would proceed to conclude the proceedings as per law.
No, my lord. They have to give so cause notice, my lord.
Come, my lord. Limitation issue will come. That's why. That's why my request
No,
is
so
let
what-
them appear before the reply filed before the show cause notice.
Correct.
DRC-01 ಆದ್ರೆ ನನಗೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಕ್ ಬರಲ್ಲ. If any discrepancy is there.
No, my lord, the period is 21-22, my lord. That we will not question the limitation, my lord.
Showcase notice.
You are saying from which stage?
If they submit in a showcase notice, ಸ್ವಲ್ಪ time ಸಿಗುತ್ತೆ ನನಗೆ. We can pass an order, but we can't issue a showcase notice because of limitation, my lord.
So you are saying let the show cause notice
Yes, my
remain.
lord. Let them produce before the reply filed before the showcase notice. We will consider. If they have any evidence, we will definitely consider, my lord.
So you are saying let it be to the stage of
Showcase notice,
reply to DRC-01.
No, no, my lord. DRC-01 is before issuing showcase notice, my lord.
No, no, DRC-01, my lord. Showcase notice. 01 is before, my lord.
Correct. So
Yes, my lord.
you are saying reply to 01.
Yes, yes, my lord. Showcase notice.
That I don't know, madam. Now this annexure B1.
Yes, ma'am.
So
That is showcase notice, my lord.
So we'll say reply to B1.
Yes, ma'am.
That's what you are saying.
Yes, ma'am.
You can go back and DRC-01, you will not question the limitation, my lord.
That you say, you take a call. Now, if it is remitted to this stage, would you be prejudiced? Reply to DRC-01.
Because 01 stage, if they convinced, no requirement to give showcase notice at all, my lord. There is no requirement to give showcase notice at all, will not arise, my lord.
Then can we protect the limitation for?
Yes, my lord, I will not question the limitation.
So can we order saying that the question of limitation would not be raised if DRC-01 is issued?
01, reply to DRC-01 is done. Please, my lord.
ಒಂದೇ ಆಗಲ್ಲ sir. Limitation ಬರುತ್ತೆ.
No, 01.
Will not question the limitation.
That mentioned.
Last
Right.
No. In the event not being satisfied with the reply to DRC-01A, if the authority were to proceed to issue GST DRC-01, the SSC cannot raise the aspect of limitation of conclusion of proceedings as order is being passed, as the present order is being passed only at the instance of the petitioner to afford him an sufficient opportunity.
Yes.
All contentions are kept open. Yes.
My lord, cost, ma'am.
Yes, how much cost?
2 crore demand is there, ma'am.
No, my lord, without cost, it may be.
Oh, my lord.
My lord, annexure A1, A2, B1, B2 is required to be cost, my lord.
ಇಲ್ಲ ಅದರಲ್ಲಿ ತುಂಬಾ discrepancy ಇದೆ. Purposely they drag the matter and even they have not declared e-way bill ಯಾವುದು furnish ಮಾಡಿಲ್ಲ.
A1, it will produce everything, my lord. It will produce all the things, my lord. Because e-way bill is cumulatively they have put 50,000 above per day basis, my lord. Individually, if you make bifurcate, e-way bill itself is not required to be.
Petitioner to pay cost of rupees 15,000 to the High Court Legal Services Authority. Annexure
A1, A2, B1, B2, my lord.
A1, A2, B1 and
B2, my lord.
Are set aside.
The cost may be reduced to 10,000, my lord.
2 crore, my lord.
Yes.
13, Sandeep.
Serial number 13, challenge to income tax proceedings. One of the main grounds, my lords, is that the notice is issued by the jurisdictional layer not faceless. But subject to what my learned friend, because I think I can serve him a copy, it may be possible to remand the matter because the proceedings are ex parte. It was sent to my old address in Trichy in Tamil Nadu, whereas I've shifted to Bangalore. Of course, the documents were on the portal. So to that extent, I am negligent in not looking at it. But physical copies have not come to me. I have not participated until my amount was recovered from my bank account. Once that has happened is when I became aware and I have now filed this petition.
Yes, Tirumalesh.
Yes, my lord, if lordship would like to remand the matter, I am open to that.
Yes, now just tell me the facts.
Please. My lords, this pertains to assessment year 16-17. Originally, my lords, the 148 notice, my lords will find at annexure B, my lords, annexure A, my lords, at page 42. My lords have that. It is dated 16th of March 2023. That
Post. Yes.
That, my lords, was issued by the jurisdiction layer. So, this is one ground which I'm seeking to urge insofar as merits are concerned. But subsequently, my lords, the assessment order, my lords will find at annexure B, page 45. My lords will see that on page 46, there's a table mentioned on that at the bottom of that, my lords, details of opportunities accorded to the SSC. All these, my lords will see on the fourth table, the fourth column, they say not received is my response. Because, my lords, these have been put before the portal. Only the fifth one, my lords, issued letter dated 26/10/23. My lords can see that. Row number 5. 26/10/20. The font is little small. But that is the only one. In the last column, there is a remarks.
Sent by speed post.
Sent by speed post. My lords will just kindly turn back to page 45. The address is mentioned there. That, my lords, is the address in the table above, the third row, Trichy, Tamil Nadu. Now, this, my lords, in fact, I shifted out in 2009 itself. All my income tax returns, I filed mentioning the address in the cause title, which is in Bangalore. Now, as per the rules, my lords, notices have to be sent to the address mentioned in the return. In fact, in the database of the portal, and the portal, my instructions are, my lords, the address gets auto-populated into every return. So it's not like I can alter the address. So from 2009 itself, I've been disclosing the Bangalore address. I cannot dispute the fact that the documents would have been put up on the portal. That is I have not been correct in visiting that. But physically, I have not been served. Assessment order was passed until, my lords, and then penalty orders also. I won't take my lords through that. My lords may kindly turn to annexure.
So those are consequential.
Those are consequential because they're based on the assessment order which is passed at annexure
Now,
B.
in this assessment order,
Please, my lords.
Just point out where they say.
Yes, I'll take my lords. Yes.
No return has been filed.
Yes.
No return.
For this year, no return has
response
filed.
to 148.
Yes, ma'am. Because that was also on the portal. I have not filed my return in response to that.
Para 3.2.
Please, ma'am.
Isn't it?
Yes, ma'am.
The petitioner. So somebody asked that I have no knowledge of tax. Can I sit in the tax roster? So I said, if you know principles of natural justice, enough you can manage.
Yes, in the writ code, definitely that is more than. Sadly, that is the case.
The petitioner has called in question the correctness of the assessment order. At annexure B. As well as the or a notice under 148 at annexure A and the order under 148 capital A small d at annexure E1. Apart from calling in question consequential proceedings including notice of demand, penalty order, computation sheet and other consequential proceedings. Now to which stage you are seeing?
My lords, may kindly send the matter back to the stage of reply to 148 notice. I'll file my return, my lords.
That
and
is
then
reply annexure, reply to
annexure A, my lords.
There is 148
notice.
That is after the AD order.
Yes, AD order and notice is consequent to the AD order.
Correct. So this notice at annexure is after the AD order.
Please.
It is the case of the petitioner that no, but now they've amended, isn't it?
Now they've amended to say it's now become 148A 123. This is up to 2024. It is ABCD.
Yes. The petitioner submits that the order passed, assessment order passed for the assessment year 2016-17 is an ex parte order, as could be noticed from the observation at para 3.2. Full stop. It is submitted that the petitioner had not made out any response, as the communication that was sent for the assessment year 2016-17 was to the address at Tiruchirappalli, Tamil Nadu, whereas the petitioner has been filing, has shifted place of business, residence, and filing returns since 2009, showing the Bangalore address. Full stop. In the case of the petitioner, that though notices may have been posted on the portal, however, the absence of physical notice to the address at Bangalore has prejudiced the petitioner and resulted in a lapse, a bona fide lapse, culminating in an order passed without reply of the petitioner. Full stop. While Land Council for the Revenue, Tirumalesh submits that petitioner ought to have informed change in residence to the authorities. As regards such contention, Council for the SSC submits that once returns were filed with the Bangalore address, according to procedure, the same address would be updated in the revenue records, and all further proceedings regarding the same SSC ought to have been sent to the Bangalore address without entering into the merits of contentions regarding service of notice. It would be appropriate to accept the explanation of the petitioner and afford the petitioner an opportunity to contest the order on merits. Having noticed that the petitioner's change in address of residence from Tamil Nadu to Bangalore and the assertion that petitioner was filing returns showing the Bangalore address right from 2009, it would be appropriate to set aside
Annexure B, C, D, and E, because B is the assessment order, C, D, E are the penalty orders.
So which now we have to set aside?
B, B1, B2, C, C1, C2.
It will be appropriate to set aside the order at annexure B, comma, impute computation sheet at annexure B1, notice of demand B2, comma, order of penalty at C, computation sheet at C1, notice of demand at C2, comma, penalty order at D, computation sheet D1, notice of demand D2, penalty order E, computation sheet E1, notice of demand E2, comma, and the impugned recovery letter at annexure F. Now, what about A and A1 now?
A, I'll file my return in response to A, Marods.
Petitioner is reserved liberty to file his return in response to the notice at annexure A.
Please.
Such return to be filed within
2 months, Marods.
Within 2 months from date of receipt of certified copy of the order. All contentions on merits are kept open.
Just one additional submission. An amount has been recovered from my account at an annexure N towards this demand. Maharaj, may kindly turn to page 150. That is my extract of my bank statement. 150. At 151, Maharaj, the third entry dated 23/7/25, Maharaj, of an amount of 6,54,449. That may be kept subject to the outcome of the process. My instructions are for press for refund, but I think that would be a little, since I have contributed to this, I should at least be kept subject to the outcome of the proceeding.
It is needless to state, recovery stated to have been affected of rupees 6,54,449 pursuant to the impugned proceedings which are now set aside would be an amount that would be subject to final orders to be passed by the assessing authority, please.
May I submit?
And subject to adjustment, please.
One submission, my lord.
Yes.
That instead of 2 months, it can be made 1 month because there are timelines to be followed subsequently.
1 month from the date of the order. Date of today, or date of the receipt?
Date of the order.
Date of the receipt.
Date of receipt of the
Date
order.
of receipt, please. That I'll
1 month.
Much obliged. All contentions will be kept.
All contentions are kept open.
Much obliged.
14 Kusumaya.
My lords, appearing for the petitioner in this case, my lords, respondent number 2 has issued a notification dated 6/10/1997, but they have issued a preliminary notification, my lords. But after the bar of 28 years, also they have not issued any final notification,
Okay, take out.
and they have not as passed.
Let us see. AG accepts notice for the first respondent.
1 month.
Muda.
Yes, Muda, my lord. Number 2 and 3. Vivekananda.
Sharad Gaurav.
Land Council Sharad Gowda is directed to accept notice. Respondent 2 and 3. Yes.
15.
Any date, my lords?
Let us see pleadings to be responding to complete pleadings within 3 weeks. Yes.
15.
My lords. 15 also, it pertains to 15/7/1997 as the same cause of actions, my lords, on depending on different preliminary notice for same level.
Same order. IA 1 of 26 is allowed. Petitioner dispensed with production of certified copy of annexure A, subject to the undertaking. Same would be produced in due course. Same order in both.
16. Prasanna Kumar.
Same.
16 also same, my lords, same as 14, same notification.
16. 16 same order.
16/10/19.
16 and
16/10/97 notification.
same order. 16.
16 it's similar to serial number 14.
Yes.
17. Prakash Hemant.
Please. Lord, an endorsement issued by the respondent BDA is under challenge, page 157 at annexure B. Lord, pursuant to the land belongs to the petitioners, which was notified and acquired for formation of residential layout. In lieu of compensation, my lord, we have opted to take developed land. On an earlier occasion during 2018 itself, my lord, in the name of the second petitioner, a consent award was passed, and pursuant to which 5 sites which were allocated to that extent 19,000 and odd square feet area was allotted in the name of the second petitioner. But there was a dispute between the first and second petitioner, wherein the writ petition filed by the second petitioner was allowed. But thereafterwards, my lord, a writ appeal was filed in which there was a truce. Kindly turn to page 110, my lord. Annexure N.
What is this caveat note?
Caveat note. So I think the caveat, no caveat is filed. Right? So like this. In fact, I come to know that to some other extent, and the area, the BDI has filed the caveat with KR Puram land. At page 1110, my lords, annexure N. In the pursuant to a settlement, my lord, the division bench has passed an order. Kindly come to page 113. Para 4, Lord Advocate for BDA state that in the light of the settlement between the parties as above, BDA shall proceed to execute the necessary documents and complete the required procedure within these 3 months from today. Lord, 5 sites which are allocated were distributed between among the petitioners. 3 in favor of the first petitioner and 2 in favor of the second petitioner. Lord, since the direction of passed by the division bench was not complied, which forced us to submit a representation at annexure P115. Thereafterwards, my lord, as a matter of, offending our rights, the respondent BDA has allotted 2 sites in favor of one private party. Lord, at annexure S1 and S2, page 151 and 153. Lord, at this exigency, my lord, we were forced to file a writ petition during vacation, challenging issuing the, allotment of these, sites in favor of.
This is contrary to the settlement.
Yes. In fact, contempt petition is filed, and to circumvent the process of contempt, my lord, the BDA has taken this alternative course. In fact, a cognate bench of this honorable court has granted interim order, my lord, annexure T, page 154, in respect of two sites. Lord, on 7th, we have received this endorsement, which was dated 23/12/2025, the impugned endorsement 157, page 157, wherein the rest of the three sites are also cancelled. In fact, yesterday, that matter was listed, and my lord was pleased to extend the interim order, which is scheduled to be listed on 2nd of February. Wherein the private respondent is also a party. So far as in this petition, my lord, the BDA is the only.
But why do they do it when already there is an order in a connected site? The petitioner has.
In fact, I have annexed the interim order.
Petitioner sought for setting aside of the impugned endorsement. Endorsement or allotment?
ಇಲ್ಲ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ತಿಳುವಳಿಕೆ ಪತ್ರ ಅಂತ ಹೇಳ್ತಾರೆ 23/12/2025 ಲಾಸ್ಟ್ election notes, under which the allotments were cancelled.
The allotments made in terms of the settlement.
No. In fact, early, yes, I would.
And those allotments are in your favor.
Yes, in our favor, long back in 2019.
Called the endorsement at annexure V, whereby allotment of sites in favor of the petitioner were set aside.
Recalled.
Were recalled. The case of the petitioner, that the dispute between the private parties stood settled.
No, dispute in between the petitioners.
That's all, private parties.
How?
Between the
petitioners only.
Now this fellow was the.
Now
he was not a party, is it?
No. See, what happened in the previous writ petition, my lord, sir, wherein two sites were allotted in favor of third party, a writ petition in.
No, but why have they cancelled it?
Pardon?
Why have they cancelled it now?
Citing the reason that, my lord, the first petitioner, second petitioner had entered into an agreement with my paternal uncle long back in 2018.
Between the petitioners had culminated in a settlement which was recorded in WA 570 of 2025.
Please.
It is submitted that pursuant to such a settlement, earlier allotments were made. However, same have now been recalled on the basis of an agreement stated to have been entered into by the second petitioner. By the.
So the citing the reason that earlier consent award is not properly done. So
on the ground that there was a defect in the earlier consent award. Full stop. No, correct. So now we have to adjudicate, isn't it? This after they file the statement. So what is the interim order you're seeking?
Well, interim order, so far as these three sites are concerned, let the BDA shall not precipitate it. So that's, in fact, the
light of the
cognate bench has passed the interim order in the same line. Around by kindly turn to page 156, wherein
it is further submitted that pursuant to the impugned endorsement, the BDA may proceed to create third-party rights as regards the sites that were allotted to the petitioner. Accordingly, there would be an ad interim relief directing the respondent PDA not to create any third-party rights insofar as the allotment letters at annexure.
Annexure V, my lords.
No. Allotment letters. Sites.
Sites which are mentioned so far as what this annexure says regarding all the 5 sites. All the 5 sites.
Where is that? Where you have
at page 158, my lord, last page.
With respect to
last 3 lines.
With respect to site numbers and the page 150, 911. Last 3 lines. Yes, Learning Council BS Karthikeyan.
Karthikeyan appear ಆಗಿದೆ ಅವರಿಗೆ I will be permitted to
notice for respondents 1 to 5 list along with WP number.
This is 39198/2025.
Birth code.
Please.
18, Ravi Shankar SV, 18.
Great.
My lords, appearing for the petitioners.
Dilip.
My lords, may take to page 12, my lords. There is a petition seeking a refund. Extracted a small table. My lords, in the table above, on the right-hand side, my lords will see the amount which could have been adjusted is 45 lakhs. Down below, they have adjusted 2.94. I'm praying for refund of 2 crore 48 lakhs. And I've enclosed the challenge also, the dates.
Yes, find out.
They should have filed a stay application, my lords. Without stay application, my lords, the entire amount is recoverable. My lords, that is the reason, my lords, we have recovered. That's what happens after assessment order, my lords, they'll just file appeal.
But if they pay the amount, then there's that circular, isn't it? No recovery.
My lords, 20% they'll have to deposit voluntarily.
They have not paid.
That is the reason, my lords, we've recovered the entire amount. They have not done in this case.
My lord, just see the table down below. I have a carry forward loss of 10 crores. I don't have money. I am in appeal. They adjusted 17 lakhs initially, then they adjusted the entire amount. At least I am saying to the extent of 45 lakhs is okay, but please refund the balance.
Let's let them, lordships may kindly direct them, my lords, let them approach the assessing officer.
My lords, I have already filed a request to the PCIT members. May I just take my lords to page 211, my lords, 211.
Okay, but what is the position? What is the position in such cases?
My lords, 20%, as per circular, my lords, only 20%, my lords, we are entitled to recover. Let's over and above, my lords, we are refunding, my lords, of the lordships direct will refund, my lords. We'll verify, my lords, what is the status.
Find out, I'll have it next week. We'll dispose it.
Please. Any date, my lord? My lord, there is one interim prayer which I have prayed. I asked for a prayer saying that please don't make any further adjustment because since I have a loss, every year for the next 3 years, I'll have a refund.
So that will be disposed. We'll have it next week.
Please.
We'll pass some observation.
Please, my lords.
Learning Council Dilip accepts notice for the respondents. List the matter in the preliminary hearing list on
28.
Yes.
19.
Obliged.
Raju, yes.
The writ of mandamus not to seize the vehicle, very identical matter. Annex C, Annex C, in page 28, operative portion in page 29, authority. 30.
The petitioner. Yes.
I'll take notice, madam.
So same order.
2 to 5.
Same order. The matter may be posted on 19/1 to that.
HCGP accepts notice correspond 2 to 5. Union of India. So accepts notice.
Swati El Kamal.
First respondent. The Council for Petitioner submits an identical factual matrix raising identical legal question. This court in WP 38472 of 2025 has passed an interim order. Interim order passed in WP 38472 of 2025 reads as follows. Accordingly, the WP interim order restraining respondents not to seize the petition scheduled vehicle until further orders. However, the respondents are entitled to inspect the vehicles. Liberty is reserved to the respondent to seek for modification of this order if circumstances are so made out upon filing the statement. List along with the list on 19th.
Your lordship post adjourn the matter 2/2.
On
Some other matter, your lordship has adjourned the 2/2, 2nd of February.
2nd of February.
Please.
In the preliminary hearing list.
20, Sandeep.
Seal number 20 also impugns income tax proceedings. The main ground, my lords, is that the notice has been issued by the jurisdictional layer not in a faceless manner. My lords have granted stay in similar matters around 4th of February.
Fourth, today, before division bench, one matter was emergent notices issued. And next week, they've directed take up.
Will it reach next week?
Before the apex court also, it's on 30th January. Will be taken up after in the first week of February.
You should have pressed for stay.
What had happened was the connected matter was posted today.
Okay, so
The main matter, we sought a direction for a deferment of all these writ petitions. We filed an IE.
Learned Counsel Dilip accepts notice for the
Sanmati.
Sanmati accepts notice for the
Respondent.
respondents. The contention of the petitioner that notice could not have been issued by the jurisdictional assessing officer, but ought to have been proceedings ought to have been initiated under the faceless scheme. In light of the interim order stated to have been granted in light of disposal of the writ petition in connected matters, it would be appropriate to stay
Annexure B, B1 and M, my lords.
Annexure B, B1 and M. List. Shall we club all those matters?
Lordships may kindly have in a separate list, separate list for this case.
List.
Club.
List on.
4-2.
On 4-2. Barkombedu.
Just one submission.
IA 1 of 26 is allowed and petitioner dispense with production of original certified copy. Subject to the undertaking, same would be produced in due course.
For serial number 13, my lords were pleased to dispose of the matter. There, my lords, the bank account has also been frozen. My lords should kindly observe that the attachment could be lifted in the meantime, because otherwise I won't be able to operate that account. The account from which the amount was recovered, they've also prevented me from, I think, Tirumalesh was
what we did is they had recovered some amount. So that we say
The Lordships may kindly have subject to outcome of the.
that we have made
already done.
Insofar as the recovered amount. The freezing of the account
Clear.
will have to go.
Clear.
One sentence. Further submitted that apart from recovery, the account of the petitioner, what is where the
At
details?
annexure N, my lords. It's mentioned at annexure N.
Details of which is furnished at annexure N.
N, my lords.
Had been frozen.
1 year.
Had been frozen. In light of the orders being set aside, impugned orders being set aside, the order of freezing and attachment of the bank account would also be set aside.
Oh, much of it.
You just inform Tirumala.
I'll inform. 21. Srinivas Gowda, non-compliance.
I'm for the petition blood. KDB is blood acquired the land bloods and amount blood compensation determined under section 29(2) of the Act bloods. And as per annexure blood notice is issued to the Khatedars bloods. Notice is issued to the Khatedars blood asking them to come and collect the compensation determined under section 29(2) bloods. There is a civil suit pending from the year 2010 mallards between the petitioner and the contestant respondents.
Where is that?
Annexure A is this. A is the plaint. Page number 14 mallards. Therefore, my request is let the compensation determined under section 29(2) may be directed to deposit before the civil court, so that the interest would be fetched.
Where is the letter now?
Annexure E is the notice, page number 75. One crore 78 lakhs per acre is determined.
But anyway, suit pending ಇದೆ. Suit ಇವತ್ತಿದೆ actually. Doddaballapura.
No, this is
Why are they saying that?
sent to whom?
Issued to Katedar, Adisuchita Katedar, first respondent is the Katedar of the landlords.
So now we have to restrain them from disbursing, issue notice, let them come and we'll see.
Yes, please, my lords.
The petitioner is called in question as sought for issuance of writ in the nature of mandamus to direct the respondent KIDB to deposit the amount determined as compensation before the
my lords, senior civil judge, Doddaballapura, my lords.
so that has to be done by reference or in this
In this only, let them do it, my lords. Normally, KD will do it, my lords.
before the senior civil judge Doddaballapura
Invoice number
where-
17.
where proceedings invoice 174/2010 are pending consideration. So it is submitted that the suit was 174/2010 filed for
Partition and partition, my lords.
filed for partition is pending between the petitioners and the private respondents. By way of OS 174/2010 before the civil judge senior division at Doddaballapura. In light of the same, it is submitted that the respondent authorities may not disburse the compensation. Subject to further consideration, the second respondent is restrained from disbursing the compensation with respect to the lands.
Schedule lands.
With respect to the scheduled lands till the next date. So and so accepts notice for the second respondent, AGF for first respondent, emergent notice to respondents 3 to 10. Petitioner is at liberty to serve counsel appearing for respondent 3 to 10 in the proceedings before the civil court invoice 174/2010 as well. Relist date.
22.
May it please your lordship. The petitioner, my lord, is aggrieved by the BDA's inaction in executing a sale deed in respect of the property that was allotted to the petitioner. The property, my lord, is
You have
located.
paid the lease come sale to sale deed.
Yes,
You have
yes.
paid the charges.
Everything has been paid. In fact, this is the third round of litigation. I first instituted a writ.
No dispute.
There's no dispute at all. The BDA is just silent. They are not. They either refuse to address any response to my representation, nor do they execute a sale deed, nor do they tell me that it has been allotted to somebody else. We will issue an alternate site to you. None of that.
You have to see them. You can't only see, you have to see them. Verb, not only noun.
Please.
Ah.
So in 2023,
yes, who appeared in the previous round?
your lordships may kindly take the order. The previous.
No, that I'll see. So we'll fix a date. Let the BDA.
Very
so
well.
And so accepts notice for the respondent.
One Mr. N.R. Girisha had appeared previously.
Let's see. I think the panel may have changed.
Please.
AG accepts notice for first respondent. So and so has appeared. Learned Counsel M.V. Charati is directed to accept notice for the respondent 2 and 3. List the matter in preliminary hearing list.
I have sought some interim protection that it shouldn't be allotted to somebody else. That interim protection may be granted, madam.
No, but there's no doubt, isn't it?
No, there's no doubt at all. In fact, if I may, let me just.
So we'll have it next week.
Very well.
In case they don't, then
May I just highlight one order, previous order that had been passed in this?
Okay, but I'm saying now since the lease come sale is in yours.
Yes.
Where is the question of giving it?
Very well.
Let's see on the next.
Very
one.
well. Very well.
You serve today only.
Please. A date may be fixed.
19.
19. I'm so grateful.
23.
So verb and noun. See noun. You have to see also means verb.
Please.
23.
Other adjectives we will see later.
Very well.
23. Bhargavi SV.
Appearing
Yes.
for the petition. My lord, office has raised objection, my lord. council submission is mentioned. As we have annexed the quashing annexures orders which we have downloaded it from the portal, my lord.
Office objection is overruled, accepting the submission of the council. Yes.
My lord, petitioner is a registered dealer under KGST Act, my lord, carrying out the business of transport of RMC and cement supply. For the financial period 2022 and 23, the petitioner had filed his returns, my lord. The second respondent passed an order alleging that the petitioner had failed to file his returns in GSTR 3B for the period March 2023, April 2023, June 2023, and July 2023. In fact, the petitioner had filed his returns, my lord. It has been annexed in annexure B2, B3, my lord. And without providing the adequate opportunities, my lord, show cause notice has also not been served on the petitioner, my lord. Best judgment assessment order has been passed, my lord.
CGP accepts notice for the respondents. This is the matter in the preliminary hearing list tomorrow. They have already filed. No, return. They say they have filed.
If you could see annexure C, my lord.
Find out. They are saying that they have filed. That you just verify.
Please.
If they have filed, then we can set it aside. If they have filed.
24, Vijay Kumar K.
Annexure A is better copy, my lord. It is objection, my lord. Readable copy. And
Office objection is better copy required. Date, etc. Anyhow, I'll keep it open. You file it. The office objection is kept open. In light of the undertaking, the better copy would be filed within 2 weeks. What is the matter?
We filed application for enhancement of compensation. It was rejected by the DC on the ground of limitation, stating that within 3 years from 12/7/2017, I have not filed. The 3 years Article 137 is not applicable to the National Highway Authority, since there is no limitation under the National Highway Authority Act. Number one. Number two, my lord, even taking into consideration of the impugned order 12/7/2017, 3 years limitation would expire on 12/7/2020. Milord, the sumoto proceedings COVID period benefit, Milord, will come in this matter. The connected matters, Milord, has been ordered by 15/3/2020 is the limitation under the sumoto SLP, Milord, in the Supreme Court till 15/2/2022. 2 years limitation has been excluded from the period of matters pertaining to between the covered period.
Then plus.
Yes. Therefore, it is 15/12/7/2020 comes within the 15/3/2020 to 15/2/2022. Therefore, technically they have rejected, Milord, and connected matters, Milord, coordinate bench, Milord, has considered this aspect and allowed very same deputy commissioner orders, Milord.
You want to find out, or will next week and or will allow?
All cases to decide on merits, Milord, as referring the COVID benefit, Milord, in sumoto proceedings. Paragraph, Milord, is 4, Milord. Internal page 4 only. It is further clarified. Next paragraph. Internal page 4, second paragraph. It is further clarified that period from 15/3/2020 till 28/2/2020 shall also stand excluded in computing the periods of prescribed under section 23(4) and 29A of the Arbitration Conciliation Act, 12A of the Commercial Court Acts, and provisions of section 138 and any other laws which are prescribed period of limitation for instituting of proceedings, outer limits which within this court tribunal can condone the delay and termination of the proceedings. My period will comes 15/3/12/7/20 within the period of 15/3/20 to 28/2/20.
When was the order passed?
The order, impugned order, Milord. Impugned order is 10/1/24, but the award notice, Milord, on 12/7/17.
12/7/2017. And you are required to file within
3 years.
in terms of section.
Article 137 of Limitation Act. The 3 years would be expired on 12/7/2020. It is between the period.
137 is 3 years. So the 12/7/2020.
Yes, my lord. Benefit excluded period is 15/3/20 to February 22, 28 to 22. Sumoto writ petition in the affects court, my lord.
Application filed on 8/4/21.
That also within the period.
So 3 plus this 20 to 22 plus 3.
Yes, ma'am.
That's what you're saying.
Within that period, 2022, 12/7/22, 3 years period. My lord, that benefit of period, my lord, is expired on 12/7/20. It covers within the period of COVID benefit. My application is filed on 8/4/21. That also within the period of 2022, in between period, my lord. COVID.
The
Respondent number 1, I will accept notice, my lord.
uh,
2 and 3, MN Kumar, my lord. In Kumar.
EJ accepts notice for respondent 1. Then Council N. Kumar for 2 and 3. This is the matter in the preliminary hearing list on second.
I will serve.
It one copied one. Yes.
25.
At appearing for
K. Nagarajan.
at annexure F, my lord, there are partially, my lord, have produced the order sheet, but the entire order sheet is produced at annexure B, my lord. It's only a repetition. I printed the entire, my lord, the order sheet at annexure B. What I have produced is only relevant at annexure F, my lord.
Office objection. Let's see number 1 is overruled in light of the nation made. What is 2? 2 is complete copy.
That is, my lord, that is a complete copy. I have not produced it. That is their case for annexure F. I produced in annexure B the entire complete copy.
In light of the explanation made, office objection at 1 and 2 are overruled.
But I have not sought for any interim order, my lord. My land, my lord, the land was acquired by the, my lord, the BDA. Alternatively, my lord, they have promised that they will allot in Vishweshwar layout, as usual, your lordship has seen. But they have not done it, my lord. So I give a representation.
AJ accepts notice for the respondent. BDA. Then Council K. Krishna is directed to accept notice 1 and 2 and 3. ಹುಷಾರಾಗಿರ್ಬೇಕು ಆಮೇಲೆ ಸೈಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಮನಿ ಲಾಂಡ್ರಿಂಗ್ ಕೇಸ್ ಹಾಕಿ.
ಅಲ್ಲ ಎಲ್ರಿಗೂ ವಿಶ್ವೇಶ್ವರ ಲೇಔಟ್ ನಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ ಕೊಡ್ತೀವಿ ಅಂತ. ದನ್ ದೇ ವಿಲ್ ಗಿವ್ ಟು ಮೈ ಲಾರ್ಡ್ ಕೆಂಪೇಗೌಡ ಲೇಔಟ್. ಕೆಂಪೇಗೌಡ ಲೇಔಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಈಗ ಹೊಸದಾಗ ಕಾರ್ ಅಂತ.
ಆನ್ ಅ ಲೈಟರ್ ವೇನ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಸೈಟ್ ಕೊಡ್ಲಿ ಮನಿ ಲಾಂಡ್ರಿಂಗ್ ಕೇಸ್ ಬೇಡ. Yes.
Serial number 2, Sheshagiri Rao, Pradeep Kumar.
It's a matter where not the collector or the special land acquisition officer is holding an inquiry in contravention to section 64 of the new land acquisition act. Not the key.
Just 1 minute. Manjin, yeah. Correct. Bring him because there is some urgency. You bring him as soon as he comes. I'll take it up.
You Pradeep. Itu ಬೇರೆ KDB. No, not. I think he's mistake. No. List 2 serial number 2. You just get Pradeep Kumar. Just check where he is. I will request Mr. Pradeep.
As soon as he comes, I'll take it up.
Please.
List 1, passed over matters. Serial number 5, Senthil Kumar. List 1, serial number 5. Serial number 6, Santosh Sagar.
List 2, serial number 3, my lord. List 1, list 2.
Apologies. Serial number 6, Santosh.
Lordship, the challenge in all the three matters is against the penalty orders. The challenge to the assessment order is already pending before this honorable court.
Pending.
Pending,
There's
Lordship.
stay.
In the same assessment year, they may be connected, Lordship. Serial number 6 is for assessment year 23-24, Lordship. Serial number 7 and 8 are for assessment year 2023, Lordship. The matters may be tagged to the respective years. It's served to Sanmati.
The petitioner. This is serial number. First, we'll take one by one. Serial number 6. Land Council Sushal Tiwari accepts notice for the respondent. Petitioner submits that the challenge is to the penalty order.
Okay.
Challenge is to the penalty order.
Yes, Lordship. Under 270A.
Under section 270A, it is submitted that the penalty order relates to the year,
Assessment year 23-24.
to the assessment year 23-24, and as regards such assessment year, writ petition number
36014.
36014 of 2025 has been filed, and there is an interim order of stay of the assessment order. In light of the same, there would be stay of
Annexure F, penalty order,
Annexure F,
dated 23rd September 2025.
dated 23rd September 2025, list along with WP 36014 of 25. Now next,
7.
Lordship, serial number 7 and 8, Lordship. Serial number 7 is the challenge to the penalty order under section 270A. It pertains to assessment year 22-23, Lordship.
so same order.
Same order, Lordship.
So the writ petition number mata
No,
change.
it is for a different assessment year, Lordship.
Correct.
Yeah. Serial number 7 and 8.
Correct. So what I'm saying, it will have to be clubbed with 37663.
Yes, Lordship.
Same order, huh? Writ petition assessment order challenged in 37663 of 25. Otherwise identical. And annexure, stay of
Annexure G,
stay of annexure G.
dated 21/6/24.
G.
8. Santosh Sagar.
The penalty order is under section 271 AAC, Lordship, arising from the same assessment order for the same year.
Which year?
22-23, Lordship.
The present writ petition has been filed, calling in question the correctness of the penalty order under section 271
AAC,
capital AAC within bracket 1 of the Income Tax Act. It is submitted that the order of penalty relates to the assessment year
22-23.
22-23, and as regards such assessment year, the order of assessment has been challenged in WP number
37663
37663 of
25.
and interim order has been passed. In light of the same, there will be stay of the order at annexure K. List along with WP 37663 of 25.
Deeply obliged.
Serial number 9. Rajiv Chennappa.
Your Honors, I am appealing for the petitioner, Your Honors. This petition is regarding the cancellation of GST registration.
Just 1 minute. Yes, central tax, is it?
Yes, Your Honors.
Yes. He's saying that.
Your Honors, in Annexure C, which is the show cause notice for the cancellation, this show cause notice was vague.
Okay, you serve a.
I'll let them serve a copy, my lordship may have it next week.
Your Honors, let it be on Tuesday in preliminary hearing, Your Honors, because the GST registration is cancelled. The assessee's livelihood is affected.
Yes.
21st, man.
Learned Counsel Arvind Chavan accepts
Copies to be served.
notice for the
I'll serve it
respondents.
today during the day, Your Honors.
Copy to be served forthwith. This is the matter in the preliminary hearing list on. Yes.
Much obliged, Your Honors.
Now that these contentions has been coming from so many years.
But,
in the software you have.
No, my instructions are that the software does not permit them to include a additional paragraph or a detailed paragraph. It only permits them to pick and choose what are the sections and what are this thing. There is a software algorithm, my lord. In that they have to pick and choose, my lord. That is the sole reason why the detailed explanation it is not coming regarding only
But Your
regarding
Honors,
cancellation.
but Your Honors, in some cases they issue an annexure wherein they issue a detailed violations of the why the show cause notice has to be cancelled.
It is a computer generated, automatically if returns are not filed for 6 months, my lord, computer generated notices will go to their portal. In some cases, my lords, where it requires any application of mine, there is a drop down options. Returns not filed for 6 months. Place of business is not found correct. Some 4 or 5 options are there. When we get into others, probably I have advised my officers, my lords, to annex a document as a show cause notice and explain in detail as to reasons why you want to cancel the registration. But otherwise, my lords, it's computer generated.
My lord, even before issuing the show cause notice, they would have issued a summons, my lord. Assessee would be put on notice why the summons has been issued. He would have even filed the reply. Then show cause notice would have been issued. So all that petition saying that I don't know anything, they have just in an erratic way, they have just issued one word or something, may not be properly right, my lord. Because already summons would have been issued, they would have filed a reply. Then we would have issued a show cause notice, and then we would pass a order for cancellation.
List in preliminary list also. Yes.
Much obliged.
List 2, serial number 2, Sheshagiri Rao, Pradeep Kumar.
Issue with respect to apportionment of compensation lots. There is a civil suit pending between the brothers for partition. So now there was a previous order stating that the
page
Lord, annexure A, page 20.
24 minutes, the direction is there.
Relevant portion, Lord, 24, para 4, my Lord.
Para 4, para 3 and 4.
3 and 4.
Now, my lordship knows that the KADB Act says by incorporation taken these section 64.
Now this writ petition order was passed between
April 2025.
Now the same. Now what they've done?
Now again, he is holding an inquiry, for the purpose of apportionment. Annexure H. Notices have been issued. 59.
Now this order in the writ petition was passed with respect to similar notices.
Same notice, where he was supposed to hold an inquiry, for apportionment. We objected that either it has to, because of effect of section 64, it has to go to the civil court.
Correct. Then why, how you are again doing this? Now you are a party in WP 6230. What is the reason why this notice is issued again?
Lord, to hear them, Lord, notice has been issued. Now, Lord, after hearing if there is any dispute, we will have to, Lord, refer the matter to, Lord, the civil court.
Civil
court, that has to be decided by the SLAO, Lord, whether there's dispute or not.
Section 64 is a hands-off.
The SLAO, Lord, is a quasi-judicial authority. Lord, he has, Lord, powers.
I just point out, what is the effect of section 64? It's a hands-off. The moment, any person interested, it states so for a moment, if I could just take your lordships.
No, let us see what we could do. We can only say that.
Lord, you last kindly see para 4 of Lord, the judgment, Lord.
No, correct. So what we can dispose it of?
Pursuant to the direction of this court, Lord, hearing is, Lord, taking place. Lord, after hearing, if Lord, SLO finds, Lord, any dispute, Lord, rival claims.
Correct. We can do one thing. We'll only tell them you don't disburse the amount. Please, till you decide, and we'll keep it pending. Afterwards, let him take a decision in terms of that notice.
No, my lord, it is posted for orders after hearing the
Correct.
parties.
We are only going to say, don't disperse it for the time being. You take a decision. Let us see. Now, suppose you transfer it, there ends the matter. You don't transfer it, let us have a look and then we'll decide.
That should be.
The petitioner submits that in terms of.
Lord, in para 5, that is already been, my lord.
Correct. But what to do when it comes to.
Until consideration of, my lord, the objection of petitioner.
When it comes to money, anything can happen. That's all he's scared. It's not that.
Similar, my lord, arguments were made, my lord, earlier. Lord, this court, my lord, after hearing, my lord, both the, my lord, side, my lord, passed this order, my lord, protecting its interest in para 5 of, my lord, the order. Para 5, my lord, is categorically, my lord, says that, my lord, the SLO is not to disperse the compensation unless, my lord, he considers the objections of the petitioner. Lord, now it is posted for orders.
Some intelligence he has that you don't have. So why would he have come?
That is true.
Something is there.
But thing is, my lord, the suit, my lord, came to be filed only after, my lord, the 28-1 is issued.
No, no,
Lord,
it's
suit, my lord, your lordship kindly see, my lord, the plaint. It's 2023. Preliminary notification was issued.
Pendent letter, there is an acquisition.
So finally, as against that order, there would be an appeal, isn't it? Suppose he passes an order.
Lord, suppose he passes an order saying that, my lord, there are rival claimants, so cannot be. You have to refer the matter to, my lord.
There ends. But suppose he were to reject, then against such order of rejection, he'll come back here only.
That may be recorded, my lord. That may be recorded. If it is rejected only, my lord.
He's posted it for orders.
If it is, my lord, his objection is accepted, and, my lord, the order is passed, my lord, he'll have no grievance.
Would not survive.
That matter has to be, my lord, referred to the, my lord, civil court. If it is rejected only, my lord, we don't know whether it will be rejected or not. We can't anticipate the thing.
But what is your apprehension
now? Now, because the hearing was attended, the SLO is of the opinion, you are in a partition suit. I will start releasing portions of this compensation. Now, what happens, is in a suit for partition. In an FTP, while we go for apportionment allocation of our shares, previously sold assets, will be set off.
Okay, let the other side come, we'll settle it.
Yes.
So, till
the respondent number.
Private respondent
respondent number 3 is restrained from disbursing the amount while clarifying that the said respondent is at liberty to pass appropriate orders pursuant to the notice at annexure H. Interim order would be enforced till the next date. AG accepts notice for 1. Emergent notice to the private respondents. Petitioner is at liberty to serve the private respondents by serving on the counsel for the private respondent who appears in the before the trial court.
In OS number 1 of 23.
In OS number
1 of 23.
1 of 23. Yes.
Date may be fixed, my lord.
Relist the matter, date code 2 weeks.
The same.
9th February.
Great.
List 1, serial number 26. Harish.
My lords, this matter was heard at length on 5th Jan, my lords. This is the issue where the importer had imported goods on under CIF basis, and it's covered by the Gujarat High Court decision, my lords. The service tax is not applicable in such case where the import is made by the importer under a CIF basis. On the ocean freight, service tax is not applicable. This is covered by Gujarat High Court, and this was brought to your attention on 5th Jan, my lords. And my lords had asked us to produce a copy of the note on each decision that we are relying on. And I'm producing. Copy.
Just take me through a synopsis.
Yes, my lords. My lords, the issue here is only pertaining to service tax liability on the ocean freight, my lords. I am an importer and I have my contract with the foreign supplier is only on CIF basis. That is where the foreign supplier would undertake to pay the cost, insurance and freight of the goods that he is supplying to me. And until the goods reaches the customs port or the Indian port, the entire contract or the entire transportation of goods would be undertaken by the foreign supplier. The foreign supplier gets into another contract with the foreign shipping line, where the shipping line or the shipper, shipping agent would undertake to transport the goods, and he would, the foreign supplier would be liable to pay the freight to the foreign shipping line. In this case, the petitioner, being the Indian importer, is nowhere treated as a service recipient. I am only receiving, or I am only the recipient of the goods that I have been, for which I have paid the entire amount, and also the customs duty is paid on the import of goods. Therefore, the service tax liability on the ocean freight, which the foreign supplier has paid to the foreign shipping line, I am not privy to that contract law. Therefore, the liability on me would be unsustainable, and the department has sought to levy service tax based on, in accordance with two notifications, which has been challenged before this Honorable High Court in the present writ petition, notification 15 and 16 of 2017. My lords, as per the service tax provisions, initially from 2012 onwards, under section 66D, under the negative list, the transportation of goods by vessel was placed under the negative list up to 2016, my lords. Thereafter, from 2016 onwards, the levy on I'm sorry, my lords. From 2012 to 2016, the service tax levy there was no service tax levy on the Indian importer for importing the goods, and there was no levy on the ocean freight charged by the foreign shipping line, and there was no liability imposed on the Indian importer, my lord. Subsequently, by way of mega exemption notification, which is also produced before my lords, where they had excluded this levy, saying that it is only if the contract is between a non-taxable person, a foreign shipping line, and the foreign supplier, that the levy of service tax on the such ocean freight would not fall under the mega exemption notification. Thereafter, there was another notification, that is 30 of 2012, wherein the levy of service tax on this ocean freight was liable on the Indian importer under reverse charge mechanism. There was an explanation that was added to this notification, which was substituted by way of the present notification, which is under challenge in this present writ petition, my lords. So the explanation says, if the foreign supplier has supplied goods to the Indian importer, and the foreign supplier has entered into a contract or an agreement with the foreign shipping line for transportation of goods, foreign supplier as well as the foreign shipping line being two non-taxable service providers service providers who are in the non-taxable territory, the Indian importer would be liable to pay the service tax. However, our submission is that I am only importing goods from the foreign supplier, and the contract is entirely on CIF basis, cost, insurance and freight, where I have entirely paid the freight to the foreign supplier. I do not have any arrangement with the foreign shipping line. I am not privy to the contract between the foreign supplier and the foreign shipping line. Therefore, when the freight is paid or borne by the foreign supplier, I do not have to bear the liability of service tax for the ocean freight that is charged, because I have already paid the customs duty in this case for the import of goods.
So what does the Gujarat judgment say?
My lords, I have produced a copy of the Gujarat High Court in the compilation which was furnished last occasion, my lords. Page 69 of the compilation.
Sal Steel.
Sal Steels, my lord. page 6, in this decision of Gujarat High Court, they have struck down the constitutionality of the notifications, both 15 and 16 of 2017, my lords, and they have held that service tax is not payable in case of ocean freight by the Indian importer, paid by the Indian importer, my lord. Page number 69, the court has in detail given explanation as to what is CIF based contract, and subsequent.
Now, anyhow, this adjudication holds good.
So sorry, my
The
lord.
adjudication holds good.
Yes, my lord. Sal Steels holds good, and it has been affirmed by Supreme Court in another case, which is Commissioner of Service Tax versus Kiri Dice by the Supreme Court, my lord. That is in page 11 and 12 of the compilation.
But some other SLP is pending, is it? No. So this has been affirmed
There is no stay granted in that, my lord.
That matter.
Sal Steel is pending, but the stay is not granted in that.
Okay, let us see. Pass over, let them come.
My pleasure.
Pass over. It requires some hearing now because of the pendency of that matter.
Yes, my lords. Sal Steel, the matter is pending before Supreme Court, but there's no stay, my lord. But the Gujarat High Court decision of Sal Steel has been affirmed by Supreme Court in another case, my lords.
The Gujarat High Court again was on Sal Steel on the basis of
Same Sal Steels only, my lord. So there was another case called in Kiri Dice, which was before Sestat Ahmedabad, and the department went on an appeal before the Supreme Court challenging the Sestat order. The Supreme Court has affirmed the position taken in the Gujarat High Court decision in Sal Steel's below.
Let us see. Pass over.
27. 27.
Your Lordship, the issue pertains to rejection of refund with respect to export of services.
Booklet. Yes. Yes.
The issue pertains to rejection of refund with respect to export of service, Your Lordship. And this stands covered by 2 judgments of the Karnataka High Court, as well as a circular. But my learned friend wants time.
My lord, in this matter, I would require some time, my lord. Though the petitioner contends that it is covered by our own High Court judgment, I have not yet got instructions. Lordship may kindly have it in first week or second week of February, my lord. In that time, either I'll complete my pleadings, or if it is covered, I'll make my submission.
I'll grant you time. What is the judgment? Just show, let us see. You must always hit when the other party is not ready. Ex parte arguments are more appealing.
This is an issue, my lords, where I render ITES support services to my affiliate entity in Singapore. Now, generally, when I do exports, my lords, I confirm what is the recipient of services and what he receives in Singapore, my lords. There are 2 provisions under the GST Act. One is section 2(6) and there is one more section 13(3)(a). 13(3)(a) talks about place of supply. How is place of supply determined, etc. There are conditions on how you determine exports. And thereafter, once I do the export criteria, etc., I can avail the refunds of all the inputs I have used for the purposes of exports under section 16. Now, there are certain conditions that are prescribed as to when a transaction is determined for the purposes of exports. That is determined under section 13(3)(a). One of the conditions is place of supply. When a supply is done within India for a certain transaction, etc., I don't qualify for an export. Now, this is a case, Lords, where the entire activity and the recipient of the services happens to be the affiliate entity in Singapore. The conditions are that I should have a contract with them. I should receive a foreign currency remittance from them, etc. The remittance has to happen, the invoice should be in foreign currency, the remittance has to happen in foreign currency, etc. And therefore, the ultimate recipient of that service should be the service recipient who's located abroad. Now, Wipro G is one such judgment which I have passed along to my lords, where this entire issue has been recognized by this honorable court.
But now then he'll have to take a stand. He has to complete.
Yes. Now what has happened, my lords, is this is a period for 21-22. In the subsequent period, since this is a central authority, my lords, in the subsequent period for the year 23 and 24, in their Pune division, my lords, they have accepted this transaction to be an export transaction. An audit happened in 23-24. They've accepted this transaction to be an export transaction and they've disallowed the entire audit has been set aside. So basis that itself, my lord, they can take the stand saying that this transaction amounts to an export.
Complete the instruction. Respondent to complete the instructions by the next date. Relist on
10th of February.
10th of February. Yes.
28. Okay, Vijay.
For the respondent.
One more repetition, Milord, is connected repetition WP 38225 of 25 will be 38225 of 2025. Milord, on 19th it was listed, Milord, in that matter, Milord, this matter, this WP to be tagged with that because it is a writ of mandamus I filed against the BDA not to allot the property since the subject matter of the lease is pending before the Justice, Honorable Justice Keshav Narayana Committee. Madam, land has been acquired, our land. We challenge the notification.
So now we have to
tag that, connect with that matter and
list along with WP 38225.
Because I have not been served a copy of the other writ petition.
other order notice was ordered already. Peace process also paid.
I not set for you.
Okay.
List along with WP 38225 of 2025.
38-225 bar 2025. And interim order in this matter may kindly extend, Milord.
Interim order in operation is extended till the next day.
In this matter, my lord, I'm not too sure.
This
about
matter
that.
only. This matter.
You serve her a copy.
Yes,
29 adjourn 30. Vinay N. AGA. Vinay.
Respondents are to file objection.
Respondents to file their statement of objections within 2 weeks. Yes, list thereafter.
31. Shivkumar.
Your Lordship, interim order 2 weeks.
Interim order in operation is extended till the next day.
31. Shivkumar. AGA.
Yes, my lord. My lord, this is an order under section 107 of the GST Act. I have also questioned the order under section 129 of the GST Act. I am a transporter.
Register here.
I appear.
In one matter, some M. Kumar was saying, in which matter, something that
37, 38 is also mine.
37, 30. Okay, yes.
I am a transporter. I was asked to transport some goods to a client in Bangalore from Sonepete, Haryana to Bangalore city market. So I was transporting goods from Sonepete to railway station Delhi. From railway station Delhi to railway station Bangalore, there was a valid GST invoices and e-way bill was there. Kindly see page number 84. 84, this is a invoice raised by this supplier at Sonepet. Then the invoice, e-way bill at page number 85. The invoice row number 5 says the valid up to 15/11/2024 and the supplier name and the recipient name is there. Document date 4/1/24. At the end, it is mentioned.
No, just 1 minute. Now, notice issued, not yet.
Fresh, I think so.
Fresh matter.
Once already heard.
Huh?
Earlier it had.
Tribunal not yet formed, my lord. I will file statement of objection, my lord. I need time, my lord, 4 weeks time, my lord. There is no urgency in the matter.
This is actually the violation of rule 1. There is no requirement.
Let them take the stand, then we'll take it.
As per sub rule 5 of 138, from the railway station to the place of recipient, if it is less than 50 kilometers, there is no requirement of updating e-way bill. So this is only 3.5 kilometers from railway station to the allegation is I did not update up to railway station. The e-way bill was there. If you can kindly see.
Okay, but let them find out.
Yes, my lord. I will seek
inspection at least on facts, and then we can decide. Let HCGP to complete instructions within 3 weeks.
3 weeks.
Within 3 weeks. This is the matter thereafter. Yes.
Yes, madam.
32. Vetanayak N.
Appearing for petitioner, my lords.
The notice should be issued to State National Highway, my lord.
pertaining to National Highway State, my lord. Here, my lord, Assistant Executive Engineer, National Highway and Care Circle, my lord.
My lords, senior is
Pertaining to
not
State
keeping
National
well, my
Highway, my
lords.
lord.
Senior is not keeping well, my lords. Tomorrow may be heard. Case may be heard tomorrow, my lord.
Interim order earlier granted is extended till the you file a memo for extension of interim order. Now, who has to appear for R1?
I think some AGA, my lord. AGA will take
Number
notice.
1
My lord, yes.
You are verified.
No, my lord, I verified, my lord.
Verified.
It is pertaining to State National Highway, my lord. So certain roads have been handed over to state, my lord.
Assistant Executive Engineer, my lord.
AG accepts notice for the first respondent.
Special
Respond number 1, 3, my lord.
two
only the National Highway.
ಅದು ಸ್ಟೇಟ್ ನೋಡಿ ಕ್ಯಾರ್ ಸರ್ಕಲ್ ನಿಮ್ ಬರುತ್ತೆ.
Then respond 1 to 3, I only take.
AG accepts notice for respondents 1, 2, 3. Office to delete the name of learned counsel Sri N. Kumar is representing R1. You file a memo for extension of interim period.
Yes, ma'am.
Learned counsel for the petitioner submits though the interim order was passed on 8/12/2025 by bona fide lapse. Same was not extended on 18/12/2025. In light of the memo filed, the interim order passed on 8/12/2025 is extended till the next date. List after 2 weeks. Yes.
33, Krishnan.
Memo application. Yes.
33, Radhakrishnan.
Relist. Relist. Date.
34.
Adjournment is 25 matters. Matters adjourned.
I appeal for,
Yes.
for the respondent, my lord. I have just IA only. The petition copy is not available with me. my lord.
Petitioner
Maybe
to serve.
directed the
Copy of
petitioner to
petition
serve on
papers
copy.
on HCGP. List week after next.
35.
Copy. 35.
Fresh.
Fresh.
Yes.
35. ಸಮಯ ಇದರಲ್ಲಿ 74 ಕ್ಲಾಸ್ 9 ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ದು 73 ನಲ್ಲಿ ಬರುತ್ತೆ. ಆದ್ರೂ ಟ್ಯಾಕ್ಸ್ ಪೇಮೆಂಟ್ ಮಾಡಿದೀವಿ. ಇಂಟ್ರೆಸ್ಟ್ ಪೆನಾಲ್ಟಿಗೆ ನಾವು ರಿಕ್ವೆಸ್ಟ್ ಕೊಟ್ಟಿದೀವಿ ಚೇಂಜ್ ಮಾಡಿ ನಮ್ಗೆ ಅಂತ, ಆದ್ರೂ ಮಾಡ್ತಾ ಇಲ್ಲ. ಅದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದು
Serve copy. So now what is your case that you have paid the?
Actually, they have issued the order on 74 class 9. So we are not on that. Actually, 73 has to be. But still we have paid based on their notice. We have paid the tax amount. Interest and penalties waiting.
Is to be waived is what your
Yes,
request.
yes, ma'am.
Find out, let us see. AG accepts notice for the respondent. This the matter in the preliminary hearing list on.
28. 36, Prasanna PR.
My lord.
Because 73 only the period of limitation is different from what is there in 74. So probably if there is any fraud that is involved, they would have initiated section 74 and passed it on.
Find out.
36, Prasanna PR.
I am for petition.
36, sir.
36.
Lord, the appeal has been dismissed on the ground of delay, my lord. Last occasion, my lord, directed the government advocate to secure instruction. Annexure F, my lord, page number 67.
Yes. Yes.
My lord, matter may be remitted back before at the stage of show cause notice, subject to payment of cost.
Now so we set aside the appellate order.
Yes, my lord. The order is passed ex parte, my lord.
Huh,
They went for appeal
huh,
beyond the limitation.
huh.
Limitation cannot be condoned by the first appellate authority.
So we condone that on cost.
No,
And
my
then,
lord. Ex parte basis, my lord.
correct. So you're
Yes.
saying now we
Yes.
can enter into the and set-
Opportunity. Yes.
and remit it to the stage of reply to
Show cause notice.
the petitioner has called in question the correctness of the at annexure F. Full stop. Annexure F is the order which would indicate that the appeal would stand rejected in light of, within inverted comma, delay in submission of appeal, close inverted comma. In the case of the petitioner, that such order is not a speaking order, full stop. It is even otherwise submitted that the order of adjudication,
Annexure B, my lord.
annexure
B, page number 17, my lord, where the tax ascertainment was done in the audit proceedings of this office, which were communicated to ADT2, since no payments were.
annexure B, please.
Yes, my lord, page number 17, nor any response to the notice.
Which para you are reading?
My lord, second para, my lord, page number 17, my lord, whereas the above referred DRC 01A served on the notice pro register post. He has not replied,
Yes,
my
yes,
lord.
yes. ಏನ್ ಬರ್ದಿದೆ? At annexure B is an ex parte order insofar as the petitioner had not filed his reply due to bona fide reasons, full stop. It submitted that such ex parte order may be set aside, putting the petitioner to terms.
But however, my lord, page number 19, my lord, it is specifically observed, they have given reply to show cause notice. They have not attended any personal hearing despite issuing opportunity provided from the department.
Next, Lord, HCGP would submit that it's not a case of an ex parte order in, so far as the show cause notice was served and opportunity for personal hearing was fixed. However, petitioner had not availed of such opportunity.
Yes, my lord.
And full stop. Submitted that petitioner has not availed of the opportunity.
Specific personal hearing was provided, he has not appeared.
Has not availed of the opportunity.
Yes, ma'am.
Next. No doubt there is a prima facie force in the submission of HCGP regarding the petitioner being aware of the proceedings. However, it would meet interests of justice to afford another opportunity for the petitioner to put forth his response to the show cause notice on merits, which would enable a proper adjudication. Accordingly, the order at annexure B is set aside. Matters remitted to the stage of reply to the show cause
Show
notice.
cause notice, ma'am.
And such reply to be filed upon appearance.
Yes, my lord. Appear before the.
Second. Such reply to be filed. Second. Reply to be filed to the show cause notice. Petitioner to appear without further notice before the respondent number 2. Two on date fixed.
Date may be fixed.
2 weeks. 28/1/2025 at 11:30 am. Full stop. In light of the lapse on part of the petitioner the petitioner to pay costs of rupees 10,000 to the High Court Legal Services Authority. All contentions are kept open. Accordingly, the order at annexure,
Lord.
If he has failed to appear, my lord, the order may be,
accordingly, the order at annexure
annexure B may be restored, my lord.
Annexure B. Annexure
B is the 73
B
order, my
set,
lord.
B set aside and remitted to the stage as noticed
Focus
above.
notice,
In the event petitioner does not appear on the next date, indulgence granted to the petitioner by way of setting aside of order at annexure B, it stands revoked.
37. Vice Shivakumar.
Yes, my lord. This is again my appeal before the first appellate authority under the GST Act was dismissed for reason of delay. I could not participate in the proceedings and the export order came to be passed. On that, I went for a rectification. Rectification order was passed, rejecting my application. That is at annexure H, page number 61. 24/3/25, it was my rectification application was rejected. Then within 3 months, I applied for appeal. That is at page number annexure J, page number 64.
Just one. M. Kumar, which is this matter? One of the matters you said.
That was
Next matter.
38.
Okay. So 37 is different.
Same issue. Same issue on the same dealer also. Same issue and the same
Same issue,
and same petitioner.
even number I will appear, odd number sir will appear.
It's a common issue in both.
In both issues, issues common.
So then what's your stand in?
In my matter, Merge, what has happened is, as submitted by them against an order in original, they filed an application for rectification. There was a dispute with regard to whether it is filed online or physically filed.
They
However,
filed
my
an
lords,
application for rectification.
rectification. However, my lords, that application has been rejected on merits as well as on delay, my lords. It's a spare copy here.
Okay.
Sir, copy this. Sir, 38.
So it's second file, I put it.
38.
38839.
38.
Lords may kindly see page 64. Is the order rejecting the application for rectification, where they say, my lords, he rejects it on the ground that there is no apparent error apparent on the face of the record. Lords have got it, my lords. And my lords, as well as on the period of as well as limitation. However, my lords, the case of the assessee is, my lords, they have filed an appeal against this proceedings before the first appellate authority, and that is well within the period of limitation prescribed under 107. However, in the grounds of appeal that is raised, my lords, they have not taken out any ground with regard to rectification, and they have only argued the matter on the merits of the order of adjudication. Hence, my lords, first appellate authority has dismissed the appeal as saying that it is barred by limitation, since from the date of passing of the order in original, 4 months time has lapsed.
What's the limitation?
4 months, my lords. 3 months plus 1 month.
That is under section
107.
Now it was filed beyond or within.
If it is taken from the order in the original, my lords, it will be beyond the period of limit. But their cases, they have filed it against the order of rectification. So, my lords, the matter will have to be sent back to the first appellate authority to reconsider and pass orders on merits with regard to the challenge to the order of rectification.
Order of rectification. Now,
The order in original will merge with this, since he has made an observation that there is no error apparent on the face of the record. Ultimately, it will have to be decided on the merits of the application for rectification before the first appellate court.
Now, where is that order?
That's, page 29, Chanakya. Operative portion is at page 30. Because I've got column number 9, date of acceptance, rejection of appeal. There is 164th day the appeal is filed online, which
Now,
means it is
correct.
delayed by around 44 days.
Now, the third,
The physical copy is filed little later, on where it shows 74 days delay. And both of this are calculated from the date of order in original, not the rectification order.
now the order in original is passed on 14/2/25.
Copy
At annexure A, page 29.
Please.
Is that the order?
I'll just. Connect, that is the audit report.
At the third item.
In my case, annexure A, my lord, page number.
Edit file ನೋಡಕ್ಕಾಗಲ್ಲ.
Page
E, manage.
Annexure
E, page 50. Fourteen to 2025.
Okay. So this is the original order in
Order in
original.
original.
Now they've calculated limitation against.
Against this order.
Now where is that order of rectification?
Please. Page 62, my lords. I'm sorry, page 63. And it is dated 25/6/2025.
One 161 is rectification.
Please, ma'am.
161 is rectification.
Rectification. 161 is rectification.
Now, if it's rejected, then this merges with the order in original. So the limitation must be calculated from 25/6.
If they challenge this order of rectification, now they say that they had filed an appeal challenging the order of rectification. So the limitation should be calculated from this date.
Then now they state that they've challenged this annexure G1, is it?
Yes, ma'am. Annexure G. G1.
G. Now, you have challenged the order of rectification or what in the appeal?
Challenge the order of appellate authority.
Not rectification.
I mean, both the, in my prayer, I have sought quashing of both the orders.
That's fair. First appeal is filed against the order of rectification or the order of rectification. Adnili.
But in the preamble of the appeal, order of rejection, they refer to order in original.
Yes. Everywhere, here in the prayer column, they don't seek for setting aside the rectification order.
Now, how do you get over this now? Unless you show in the appeal memo, you intended to challenge the order of rectification. You can check from your appeal memo and make submission. If In effect, in your appeal memo, you have challenged the order of rectification.
The grounds of appeal is at page 72 itself. And the prayer is at page 77.
So which is the impugned order they've referred?
Page 65, my lords, may kindly see. The appeal memorandum is in GSTL APL 1, page 65, annexure H. My lords will get it at column number 7.
Yes.
That is the only thing that is done. Again, the prayer alone, they don't mention any order, the date of any orders.
Now the appeal number is, the order refers to this appeal in
Yes, this is ACCT audit DGST 04 rectification 2425 dated 25/6/2025. That will correspond with annexure G1, page 63.
Yes.
My lords have both this thing. At page 63, the number is the same as mentioned in 65.
Which number? Which number?
My lords will get it at the left-hand column. Let's stop. ACCT audit 4.8/DGST 04-RECT at page 63, my lords.
63.
63, below the phone number. Left-hand top, my lords. ACCT audit 4.8 DGST 04-RECT/2526 dated 25/6/2025. Now, my lords will turn to page 65, column number 7.
Yes.
Date of communication of the order appealed against.
And annexure H is appeal memo, and the order is at annexure
G1.
G1. No, this order, final dismissal of appeal.
Dismissal of appeal, annexure A.
So the pursuant to that appeal, the order should have referred this. That's
Yes.
all. Huh?
Yes.
Yes. The petitioner has called in question correctness of the order passed at annexure A. Full stop. The order at annexure A is an order rejecting
Annexure
the,
A, my lords, the first appellate authority has proceeded on a footing that it is filed against order in original. My lords will get it at page 29.
Yes,
The
yes.
third column, my lords.
Yes, yes.
After the name of the assessee, the third column, the order of adjudication number so
Yes,
also.
yes, yes.
So
The annexure is the order of the appellate authority, and the appeal was rejected in terms of the reason assigned in column number 9.
Please.
Of the order, which would indicate that appeal was dismissed on the ground of delay of 74 days beyond the period of 3 months, which is a period of limitation in terms of section 107 clause 1 of the KGST Act. Full stop. It is the
she has taken both the dates.
Huh?
She has taken both the dates. First paragraph relates to the appeal being filed online, which is on 164th day. That going by that, my lords, the delay will be 44 days, approximately around 43-44 days. And physical copy has been filed belatedly by 74 days.
The authority has also noticed that the online appeal was filed with delay of 164 days. Full stop. It is a case of the petitioner that appeal to the appellate authority in form GST APL 01 was filed challenging the order of dismissal of application for rectification dated 25/6/25 and relies on the appeal memorandum at annexure H. Full stop. Further submitted that if the appeal memorandum at annexure H was the appeal that ought to have been taken note of, then the order passed calculating limitation with respect to the date of passing of order in original on 14/2/25 is erroneous, and in terms of the appeal memo at annexure H, the authority ought to have calculated limitation from the date of the order passed on the application for rectification, that is 25/6/2025. Accordingly, it is submitted that the petition may be allowed. Full stop. Perused the appeal memorandum at annexure H. In column number 7, the details of the order challenged are as follows. ಅದು column 7 ನಲ್ಲಿ right hand side. The date of the order challenged is 25/6/25. Full stop. Annexure G1 is the order dismissing application for rectification passed under section 161 of the CGST/KGST Act and is dated 25/6/25. If appeal is against the order of rejection of application for rectification, the order at annexure A, which is order passed in appeal, ought to have been, while referring to the order challenged as the order of rectification dated 25/6/25, and the limitation ought to have been calculated from 25/6/25. If now, when was the appeal filed?
It is filed online on 10/9/2025.
10/9/2025. It must be noticed that under section 107(1) of the Act, the period of limitation is 3 months.
3 months from the date of receipt of the order.
3 months from the date of receipt of the order. The period of 3 months from 25/6/2025 would end on 25/9/2025. The appeal having been filed on 10/9, appeal having been filed on
10/9/2025.
10/9/2025 is accordingly within the period of limitation. Accordingly, the order at annexure A is set aside. Matter is remitted for fresh consideration before respondent number
1 month.
1. Fresh, while directing the authority to recalculate limitation in light of the prima facie observations made herein. Needless to state, limitation to be calculated from the date of the rectification order, and order be passed, appropriate orders be passed. All contentions are kept open.
The matter will be remitted back to the show cause notice level, my lord, because we could not participate in the proceedings. It can be.
They have chosen the path of going before the appellate authority. They said there is a mistake before the appellate authority.
On merits, it can be.
Let the appellate authority decide now. They may pass orders in favor of limitation, and subsequently
Then they'll go on.
Accordingly, the order at annexure A is set aside and matter remitted for fresh consideration in terms of the observations made above.
The dates pertain to WP number 38839 of 2025.
This order is 38839 of 2025. And now give the other one.
38828, my learned friend will give the dates.
In my case, my lord, even for rectification order date also beyond the limitation, my lord.
Beyond.
Because the rectification order passed on 24/3/2025.
Just one.
Annexure H, page number 58, my lord.
24/3.
2025, my lord.
Appeal is filed on.
Appeal is filed 10/9/2025. 2025.
There is no power to condone, is it?
My lord, Annexure J, my lord.
Is the appeal memorandum.
Appeal memorandum, though they have mentioned the endorsement dated 24/3/2025, but in grounds of appeal, they have not taken any with regard to rectification order, my lord. But this order taken also 4 months over, my lord, 24/3 in the 24/4, 24/5, 24/6, 3 months agoitu. Then 24/7 ಗೆ limitation ಮುಗ್ದೋಗುತ್ತೆ. This cannot be condonable at all by the first appellate authority. But they have, in prayer also, they have taken a stand of kindly be writ memorandum, my lord, turn into prayer, my lord.
My lord, that's
Page
why,
number,
my lord, that's why I have taken a stand that it can be relegated to the level of show cause notice because I could not participate in the show cause notice level. If it can kindly be.
What do you say? What do you say? What do you say, madam?
well, Allah, may be remitted back, but
The
subject to,
so which is that ex parte order?
my lord, they have taken Annexure A, my lord.
Annexure A.
Adjudication order, my lord.
In page 33, para number 13, in response to the show cause notice dated 30/12/23, RTP has not filed any reply. Then again on page 35, noticee have not filed any objections to the show cause notice. Thus it is clear that noticee has no objections to file on record.
The petitioner has called in question the correctness of the order passed under section 73 of the CGST/KGST Act 2017, read with section 20 of the IGST Act, and has sought for relegation of the matter to the stage of reply to show cause notice. Full stop. Certain other reliefs are also sought insofar as order passed rejecting the appeal in form GST APL 04 at Annexure A. Full stop. Petitioner submits that appeal
Annexure
filed.
A is the adjudication order, my lord.
Petitioner submits that the order of adjudication at Annexure A is passed ex parte and submits that an opportunity may be granted for the petitioner to place his reply to the show cause notice. Full stop. Next, it is further submitted that the order of rejection of appeal requires to be set aside as the appellate authority has taken a very conservative view of limitation and there are bona fide reasons.
My lord, sorry for interference, my lord. In his prayer, my lord, he has not this one specifically taken, my lord, contention. He has taken, my lord. Sorry, my lord. I have read Annexure B.
ಏನ್ ಬರೆದಿದ್ದೀರಾ? To explain the delay which has not been taken note of. Full stop. While noticing that order of adjudication is passed which is passed is an ex parte order, which would be made out on a perusal of the same and taking note of the consequences that have flowed while the authority has passed an ex parte order. It would be appropriate to afford the petitioner or an opportunity to take a stand on merits by way of reply to show cause notice by putting the petitioner on terms. Full stop. Accordingly, while it would not be necessary to enter into the correctness or otherwise of the appellate order, which was adjudicated only on the aspect of delay, it would be appropriate to look into the correctness of the order at annexure A itself. In light of the observation made above, the order annexure A is set aside, matter is remitted to the stage of reply to show cause
Show cause
notice.
notice.
All contentions are kept open.
But with regard to ex parte is concerned, we have served the notice. He has not appeared. He has not availed the personal hearing, everything.
Order at annexure A is set aside, matter is remitted to the stage as indicated above. Petitioner to appear before
Respondent number.
respondent number 1 on. Needless to state that if the petitioner fails to appear on the said date, petitioner would be forfeiting his right to participate in the proceedings, and the order of setting aside of the order of adjudication at annexure A would be set aside. One paragraph added. Now, DGA submits that the petitioner has not availed of opportunity, and the petitioner is solely responsible for the lapse. Next, last. Petitioner, however, to pay cost of rupees 10,000 for the lapse on his part. Such cost to be paid to the High Court Legal Services Authority. All contentions are kept open.
Much
Obliged.
39. Prasad.
It's a GST matter where I had availed the benefit under the waiver scheme, section 128A. My learned friend said he'll take instruction from the department.
Because may have it next week, no, that's because I asked for instructions, they told me the associate has informed them that they're withdrawing the writ petition.
Let us,
So they didn't come with instruction.
let us relist at request on
Next Tuesday.
Tuesday. Yes.
40. Venkesh Ji.
The petitioner, my lord.
Lord, this is that PAV and JAW matter, my lords. May I have it on 4th of February, my lords.
Relist on what matter this is?
This is the concurrent jurisdiction, my lords, faceless assessment and other one.
For R6, I'll be taking notice.
Learned Counsel Sushal Tiwari accepts notice for respondent
1 to 5.
1 to 5. Arun Chavan for R6. Relist on 4th of
February.
4th of February.
ಇದು ಲಿಸ್ಟ್ ಬರ್ಕೊಂಡು faceless.
Faceless.
Faceless. Faceless. 41.
Grateful.
Yes.
I am for the petitioner in this case, my lord. The issue under the Income Tax Act, my lord. So, my lord, this assessment here related to 1516, my lord. There was an ex parte order without serving the notice. This is a faceless assessment order, my lord. It is not served to the assessee. So, therefore, my lord, subsequently passed an ex parte assessment order saying that this that the none of notices happen.
One very like that.
Mic on mic. Page.
My lords, the assessment order, my lords, that it starts from
23,
page
my lord.
22. 23 is the relevant page, my lords.
Yes.
My lords, in the table, my lords, physical reference to verification unit as per para J.5 of SOP, my lords, of physical reference to the designated verification unit has been made in reply to verification unit report. The inspector attached to the office visited assessee's address on 1st September 2023 to serve summons, but the assessee was not available at the given address. The ITIT further reported to the reported that contacted the assessee on phone, and assessee responded by saying that he at the present is in Jammu Kashmir. Hence, the notice was served by a fixture on the address by the inspector on 12 o'clock on 1/9/2023. However, till date, there has been no response. My lords, this was done, my lords. After this also, they have not responded.
Now it was ex parte.
My lords, it's an ex parte audit.
Ask him to pay some cost.
Leave it till.
The legal service authority is being adequately enriched. Adequately.
My lords, I'll have to bring it to your lordship's notice, my lords. This case, it goes on faceless, but my lords, since they are asking for remand, my lords, I cannot oppose. My lords, the lordships may kindly refer to page number assessment
Okay,
audit.
so that issue, anyhow, whatever division bench says,
please,
that will follow.
Please, Malad, that's what I want to
Follow.
say. Yeah, please, Malad.
Also, let your lordships may kindly remand it to the stage of show cause notice, my lords. Let them
From
file
the
reply
date
to-
of the Malad, that is in 1/4/2022, in page number 23, first notice is issued. In response to
48.
that, we will reply it. Malad.
148 notice was issued on 1st April 2022, my lord. Show cause notice was issued on
1/4/2022, Malad.
1/4.
2022, in the page number 23, it is first notice, Malad. From that date, we will answer, Malad. Please, Malad.
The petitioner has called in question the correctness of the order at annexure A, which is the assessment order with respect to the assessment year 2015-16. It is submitted that the order passed is an ex parte order and non-reply to the show cause notice was due to bona fide reasons. Learned Counsel Dilip for the revenue would, however, point out to para 2 of the assessment order and submit that the efforts were made to physically serve the summons, but SSC was not available at the given address. And that further, he was made aware of the proceedings, and SSC responded by stating that he was in Jammu and Kashmir. Accordingly, it submitted that the petitioner was aware of the proceedings and has not prosecuted the proceedings diligently. Next. Peruse the order at annexure A, which is made out from the contents of the said order, that the order is passed without any response on part of the SSC to the show cause notices. Full stop. Order was passed on best judge.
Please,
Yes,
ex
ex
parte,
parte, best judge.
under section 144.
Order was passed under, what is that called?
Best judgment assessment.
On the principle of best judgment assessment in light of absence of response. Noticing the liability of tax to be borne by the petitioner, it would be appropriate for the matter to be adjudicated upon reply of the respondent, which would meet the reply of the petitioner to the show cause notice, which would meet interests of justice. Full stop. Accordingly, the order at annexure A is set aside. Matters remitted to the stage of reply to the show cause notice dated 1/4/2022. All
That is a notice, my lords. It's not show cause.
Yes,
notice.
we'll answer for that notice also.
Show cause notice, my lords, it is in at row number it's at row 5, my lords.
3/8/2023.
3/8.
3/8/2023. Full stop. All contentions are kept open. Full stop. Petitioner to report before the respondent number.
My lords, it's faceless, my lords.
Faceless, my lord, sir.
Petitioner to make out his reply to the show cause notice. Taking note of the lapse of the petitioner, it will be appropriate that the petitioner pay costs of rupees 10,000 to the High Court Legal Services Committee. All contentions are kept open.
That annexure E need to be a postponed. Subsequent bank attachment also
Further,
it is there.
For the
Annexure E, my lord, page number 38.
consequential proceedings, including the attachment of the accounts.
Please, my lord.
At annexure E would be set aside.
My humble submission, my lord. While replying the time limitations, also the permit has to take the defense, my lord. It's a time barred also. It is there. So the
All
limitation in accordance with you.
All contentions.
Much obliged. Great.
42, B. Vachan, Vishwanath.
To the respondent, my lords, my colleague who is handling the matter is unwell, my lords. Kindly, a week's time may be granted.
Relist. BDA sought for.
Please, my lords.
What's the ground?
My lords, they have taken compensation from the BDA on the ground that they own the land. Subsequently, it was seen that they were not owners of the land as on the day they took the compensation. Or rather, the land was used. Prior to the use of the land itself, they had sold the lands.
Okay, let us see. Please. Relist on.
9.
Yes.
Obligation. Interim order may kindly be extended.
Interim order operation extended to the next date.
Yes.
Please, my lord. Obliged.
Sought for, my lord, attachment to the shares. What has happened is, this is that Baiju's matter, my lord. 2,500 crores, my lord, is amount due. There have been awards passed, my lord, by Singapore court, my lord. Both injunctions had been granted by this honorable court. In respect of, my lord, the shares held by, my lord, what had happened was, there was, my lord, a company called Bearer. Bearer is, my lord, a company. Baiju, my lord, owns, my lord, entire shares, my lord, in Bearer. Bearer owns, my lord, shares in Akash. So, my lord, your lordship had passed an order, interim order, directing, my lord, that, my lord, Akash shares, my lord, be not alienated. What he does is, he sells, my lord, the Bearer shares to somebody. My lord, now we have, so therefore, my lord, we have said, Akash shares will not be attached, because Akash shares, my lord, your lordship had passed an interim order. In furtherance of that, my lord, we have said, now please direct attachment of those shares. 2,500 crores, my lord, is admitted is the amount due. If your lordship come to, my lord, the application that we have filed now, please come to, my lord, page 62, my lord's order. IA number 1, my lord, of 2026.
Page?
My lord, page 62 of that IA, my lord. IA number 1 of 2026. Not that.
2026, sir.
26, my lord. 1 of 2026.
Yes.
Yes. Page 62, my lord, if your lords has come to.
Yes.
Last paragraph of page 62, my lord. In the meanwhile, since the petitioner sought for an interim injunction to restrain the response from alienating the properties mentioned in Schedule A and B, it is appropriate that the responses are put on terms before granting an adjournment to file objections. Hence, respondents are restrained by an order of interim injunction from alienating, encumbering, transferring properties mentioned in Schedule A and B, or in any manner parting with the possession of the immovable properties mentioned therein till the next date of hearing. This, my lord, Schedule A relates to, my lord, the Akash shares held by bearer. My lords get that, my lord, in what is this IA?
IA number 1 of 25.
IA number 1 of 2025, my lord, if your lords look at. Sorry, I'm not making a split between pages. IA 1 of 2025, my lord.
Yes.
Otherly, please come to page 5, my lord, the schedule.
Yes.
My lords may come to, my lord, para seal number 3 at the bottom. All equity shares held by Bearer Investment Company Limited, an entity 100% wholly owned by award debtor number 1, that's Baiju, Ravindran, and beneficially owned by the award debtor number 1, that is Baiju, in Akash Education Services, understood to be 17,891,289 shares. This is a valuable property, my lord, of what belonged to, my lord, Baiju. Your lordships have directed that this, my lord, be injuncted from being alienated. What he does is, he, my lord, transfer the shares of Bearer to somebody, his own person. Therefore, my lord, we have now said direct attachment of these Akash shares aggregating to 17,891,289 shares of Akash.
Yes.
In fact, 2,500 crores, my lord. In fact, if my lords, my lord, look at the main execution petition, there have been, my lord, interim awards passed, emergency awards passed, final award passed, affirmed by the, my lord, the Singapore High Court. Ultimately, my lord, he owes us more than 2,500 crores. And these shares, my lord, are hardly worth about, how many, what would be the value? Akash shares. About, my lord, 1,500 crores or some such thing. Still, my lord, there'll be a gap of 1,000, over 1,000 crores.
Yes.
And in the meanwhile, my lord, I must also bring this to your lordship's notice. The person, my lord, another company had given them, my lord, loan of 10,000 crores. 5,000 crores, my lord, have just vanished. In fact, there are contempt proceedings, my lord, in Delaware court in US and all that. Anyway, that, my lord, may not have a bearing on this. In this, my lord, the short question is, the shares of Akash, my lord, which belong to, my lord, Baiju, I have asked for attachment. So that, my lord, the award doesn't become infructuous.
My colleague, Mr. Rishabh, is appearing through video.
Yeah, my lord, I appear for R1. Can I just request my lord to go to para 7 of their application? This is the application I1 of 2026.
Yeah.
This is on page 8, my lord. I read what they say at para 7. The award holder is not aware of the complete facts of the unauthorized transfer and is not privy to the terms of the unauthorized transfer. Further, the unauthorized transfer is void, invalid, and has no effect in the eyes of law. Accordingly, the award holder is filing the present application on the basis of the information available to it as on date. Now, my lord, there's a very serious suppression here. My instructing attorney, Mr. Rajat, is before you. He will show you a couple of letters and he will tender these now. The letters which the petitioner or the applicant had sent to our instructing attorneys in Singapore, which they've not put on record. So Mr. Rajat will give this to you now. Just see the first letter, my lord, which will be tendered to you now. This is a letter that they have sent, but they've not attached to their application. My lord, this is the letter from their lawyers, the applicant's lawyers in Singapore, Drew and Napier. You see that on the top. It was sent to our solicitors abroad. The first name is Lazarus Lebars, and the second name is Unan Bazu. Now see what they say, my lord. They are effectively making the same allegation in this letter. They say, para 1, we act for Qatar Holding LLC, which is the applicant here. the claimant in the above reference matters. Baiju's Investments Pte Limited and Mr. Baiju Ravindran are the respondents in the above caption matters. You so and so act for Mr. Baiju Ravindran and BIPL. Then it refers to certain orders. Now, very importantly, my lord, there's no reference to the Karnataka High Court order. They refer to the Arbitration Tribunal order and the Singapore High Court order in paragraph 2. In paragraph 3, my lord, just see what they say. Despite the tribunal's freezing order and the Singapore court's order, it has come to our client's attention that on 19th December 2025, a transfer of Mr. Ravindran's entire shareholding in BR to one so-and-so was lodged with the Singapore Accounting and Corporate Regulatory Authority, which they describe as the unauthorized share transfer. Based on publicly available news reports, Mr. So-and-so is an associate of Mr. So-and-so, has been accused of siphoning off assets and has been held in contempt of foreign courts for failing to comply with an injunction of return stolen assets. Then, my lord, in para 4, they go on to refer certain figures about certain awards that may have been issued in their favor. And just, I want to point your attention to para 6, and then I'll show you the reply as well. In para 6, see what they demand, my lord. They say, A, take all steps to rectify his breach of the orders by restoring the status quo ante to what it would have been prior to the unauthorized transfer. Effectively, they seek the same relief that they're seeking in this application. Then in B, provide full information and details and copies of the underlying transaction documents regarding the transfer of Mr. Ravindran's entire shareholding in BR. In C, confirm that the Akash shares which are beneficially owned by Mr. Ravindran are presently held by BR, and if not, to provide full information and details and copies of the underlying documents. In D, confirm that your client shall not take any steps to cause the BR shares or the Akash shares to be dealt with, parted, etc. And then see, my lord, what they say in para 7. Our client expects to hear from your clients on the above items, B to D, by no later than 48 hours from the date and time of this letter, together with a confirmation that your clients have immediately taken steps to effect the immediate reversal of the unauthorized share transfer and a description of what steps have been taken, i.e. item A. Should your clients fail to respond or provide an unsatisfactory response, our client will take it that your clients have no intention of complying with the above mentioned demands and will proceed to take all necessary legal action available to enforce its rights against your clients. Your clients are reminded once again that the Singapore court's freezing orders carry a penal notice stating, amongst other things, that your client's disobedience of the order is a contempt of court and so and so. Now, my lord, this is the letter that their solicitors had sent to our solicitors in Singapore on 4th January. Now, please see the next letter, which has been handed over by my instructing attorney, Mr. Rajat, to you. That's page 10. Do you have the letter, my lord, which on the top says Un and Bazool, our reference 2024?
Yes.
Now, this is the response that our solicitors in Singapore sent to their solicitors on 9th January. Again, this has not been put on record. See what it says. We refer to your letter of 4th January and 7th January 2026 and are instructed to respond on behalf of Mr. Baiju Ravindran, who is R1 in these proceedings before you. Our client denies any breach of the arbitral tribunal's order dated 30th September 2025 and order of court number 62104 of 2025 issued on 9 October 2025. This order is an order of the Singapore High Court. A, we are instructed that an agreement was entered into between Mr. Baiju Ravindran and so for the sale of the BR shares, please mark the words, prior to both referenced orders. We would point out that the restraints contained in the arbitral tribunal's order, which the High Court has subsequently recognized and enforced under do not retrospectively, please mark the words, do not retrospectively invalidate pre-existing agreements entered into before those orders. B, our client did not take any steps to facilitate, effectuate, or procure the lodging of any transfer after the issuance of the respective orders, nor did he instruct or assist any person to do so. He also did not knowingly assist in or permit any breach of the tribunal's order or the court's order. So we confirm that there has been no contempt. C, to the extent any corporate filings or registry lodgements were done on or around 19th December 2025, those were not done at our client's direction and were not actions taken by him after the relevant orders were enforced. Please mark those words. D, without waiving the confidentiality of the without prejudice negotiations agreed by the parties. The parties, my lord, are in settlement discussions, which is what my solicitors referred to here. Without waiving the confidentiality of the without prejudice negotiations agreed by the parties, and merely to ensure that you're properly informed, we mentioned that the ownership of BR possibly not being held by Mr. Ravindran was discussed in confidential settlement discussions on 8 September 2025. We also say so. Now see what we say in para 3. Your correspondence asserts only that the filings were lodged with ACRA. ACRA, my lord, is the equivalent of the Indian ROC. And even that has been appended, the lodging has been appended to the application that is being referred before you. So the solicitors in Singapore refer to that as well. They say with ACRA on 19th December 2025 and recites director and secretary appointment changes. Your letter's short stop of identifying any post-order instruction or facilitation by our client that would amount to dealing in the restrained assets in contravention of the orders, and none occurred. In the absence of any positive act by our client after the restraints took effect, your allegation of any contemptuous breach is unsustainable. With respect to your demands at paragraph 5 of your 4 January letter, our client's position is as follows. He has not breached the orders and therefore does not accept that he is obliged to reverse anything. B, for the same reason, our client is also not prepared to provide you with any of the confirmations or documents your clients have sought. 5. Your reminder of the penal consequences in respect of the Singapore High Court order is noted. For the reasons above, there is no basis for any allegation that our client has knowingly assisted in or permitted a breach of the order. The insinuation that our client is deploying delay to facilitate further dissipation is unfounded, particularly where his position is that he has not acted post-order to effect the 19 December 2025 lodgement. Should your clients persist in assisting contempt based solely on the registry lodgement on 19 December 2025 without identifying any post-order act or assistance by a client, we will vigorously defend the same and seek cost orders against your clients at the appropriate juncture. Now, this, my lord, was sent on 9th December 2026. There has been no response from them to this. Now, nor have they put these letters on record before you. They cannot at the same time be engaging in correspondence between lawyers over exactly the same cause of action, the same matter, threatening to take us to Singapore courts after us having confirmed that there is no breach. They have not responded to this letter and simultaneously be seeking relief before you. Now, the other thing, my lord, that I just want to point out, if you could just come to the parties that have been the entities that have been made parties in the present petition. My lord, you will see that on page 1, you see the name of the applicant. On page 2, you have Mr. Baiju Ravindran, who's R1. You have Baiju Investment PT Limited, who's R2, the award debtor. Now see, my lord, R3 and R4. They are not parties to the underlying petition at all. The award is not against R3 and R4. Yet the relief which is being sought through this application is against R3 and R4. No application for impleadment has been made against them at all. In any event, my lord, our position is that we should be given time to put an affidavit where we can explain in our reply precisely what has transpired. We have already said in inter partes correspondence and correspondence exchange between lawyers in Singapore that there has been no breach. They have not responded to our last letter. We will put all the documents on record to show that there is no breach at all.
No, notice is not served, is it, on BR and Akash?
Please, my lord.
No, my lord, they are not even parties to the underlying petition. How can it be served?
Insofar as BR and Investco and Akash.
No.
Now notice will have to go on.
Only thing is, my lord, till then, my lord, your lordship will have to protect, because if your lordship recollects, my lord, your lordship's order at page 63, specifically directed, my lord, Akash shares shall not be alienated. What are they trying to do?
My lord, there is no breach.
1 minute, please, please.
Sorry, go ahead.
The Akash shares, admittedly, my lord, belong to Baiju. 2,500 crores, my lord, is the award against him. All that your lordships have said is don't alienate the Akash shares. Now we are saying attach those Akash shares. Till then, my lord, keep it, my lord, in your lordships' custody. Otherwise, my lord, they'll fritter away. In fact, my lord, 5,000 crores have been, my lord, just vanished. They have sent it to, my lord, one coffee shop in the US. in respect
My
of
lord,
another
this is
company.
not, these
It is also
allegations do
one
not
minute,
form the
1
subject matter
minute,
of the current
please.
application at
I
all.
have to, my lord, when you argued, I did not open my mouth. Please have some courtesy, please. Please. 5,000 crores, my lord, have vanished. In fact, my lord, that's the subject matter of another petition, my lord, before another court. Here,
No, now, so
I have sought for, my lord, attachment of those shares, which, my lord, in respect to which your lordships have granted an interim order. That's all that I'm saying. Please keep it in your lordship's, my lord, custody.
now, anyhow, I will give you an opportunity to take your stand in writing. Now, the order, if any, is being passed only insofar as the definition of beer. So it does not affect you. How are you affected by it now? Let us see. But I'll keep open all contentions. We will only say by virtue of the interim order of restraint, the in effect, by virtue of the subsequent development, the interim order is not to be defeated. That's all. I'm not.
Only thing is, my lord, what
My
I would
lord,
suggest.
that I have no problem in that because I
What I
don't
would
think I've
suggest is,
defeated any interim order.
any
If
interim
that's
order
what
that your
my
lordships
lord
will
is
pass,
inclined to grant,
if,
I'm
my lord,
happy
there's
with
a
that.
violation, my lord, directly or indirectly, my lord, your lordships have the power, my lord, to reverse back, my lord. Please look at, my lord, one judgment of your lordships court.
No, I'll protect you.
That's right.
What's the only one question your lordships asked? Baiju held 100% of BR. BR holds the Akash shares. Now, what is sought to be done is a direct violation of your lordship's order. That is the one. And if your lordships do not attach the Akash shares today, then my lords, they will go away. Then what will be left with my lords is
Zero.
Zero. And after your lordship, and my lords, only one more fact, my lords. From the date of the emergency arbitrator, that is before the arbitration started, we have been fully protected through some court order, including orders of this honorable court.
Yes,
so all we are asking for is attach the Akash shares, let it be with your lordships. We are not asking for custody today.
My lord, I have just one thing I wanted to say. I have no objection whatsoever if my lord reiterates the interim order, because I have not breached the interim order. I'll be able to show that through my reply. What they cannot seek is to enlarge the protection that the court has given without me having been given the opportunity to reply and put my facts on record.
Now,
Especially in circumstances where I have already through my solicitors in Singapore confirmed that there is no breach and they've not even replied to that.
Let us see. Let us.
Because the breach.
Let us see.
He said
Just
there's
one.
no
Just
breach,
one. Just one.
The breach is evident on the
Just one.
record.
Now, the order I'm passing is only an ad interim order. So you will be at liberty to seek for modification upon filing your objection. I'll protect your contentions as well. This copy has been served on them.
Please move. Long back.
The petitioners have filed an interlocutory application under Order 21, Rule 46, read with 151 of Code of Civil Procedure. Full stop. It is noticed that the petitioners have also read in the present petition in the present application, respondent 3 and 4, that is Messrs. Beer Invest Co. Pte. Limited, as well as Akash Educational Services Limited, as respondents number 3 and 4 in the application. It is the case of the petitioners that this court, by order dated 1925, had protected the interests of the petitioners by way of an order of restraint in the form of an order of interim injunction restraining the respondent in the main petition from alienating, encumbering or transferring the properties mentioned in Schedule A and B, or in any manner or parting with the possession of the immovable properties mentioned therein till the next date. Full stop. The perusal of the schedule to the said application would reveal that Schedule A at serial number 3 includes the following, page 5 and 6 of IA 1 of 25. Full stop. Accordingly, it is noticed that the interim order passed relates to equity shares held by Beer Investco Pte and beneficially owned by Akash Educational Services.
Beneficially owned by
Baiju, my lord. Baiju
in
Ravindran.
Akash, in Akash.
Beneficially
Owned by Baiju Ravindran in Akash.
by the award debtor number 1 in
that is Baiju
Akash,
Ravindran.
in Akash Educational Services Private Limited. Full stop. It is the case of the petitioners that certain subsequent events have taken place by virtue of which the shares in Messrs. Beer have been Investco Pta Limited have been transferred
in favor of, my lord, his own henchman, my lord, called Vellappan.
transferred in favor of
One Mr. Rajesh Vellappan. Rajendra Vellappan.
Rajendra Vellappan.
in favor of Mr. Rajendra Vellappan. Full stop. It is submitted that such action has the effect of defeating the interim order passed. Learned Counsel Shri Doshi Siddharth.
My lord, Rishabh Gupta.
His name is Rishabh Gupta.
Rishabh Gupta appearing on behalf of the respondent award debtor number 1.
Yes, my lord.
Would place on record certain correspondences and submit that the petitioners were not only aware of such transfers of shares in Beer, but the transfers related to certain pre-existing agreements which cannot be restrained by the present proceedings. Full stop. Time is sought in order to file their statement of objections as well. Full stop. At this stage, taking note of the interim order that was already passed on 1/9/2025, for the present, an ad interim order could be passed to ensure that the enforcement of the interim order of 1/9/2025 is not affected. While clarifying, this is an ad interim order subject to modification by the at the instance of the respondents on filing of the statement of objections if circumstances are so made out. Full stop. Taking note of the subsequent events as stated, it would be appropriate for the present to indicate that the order of 1/9/2025 is to be affirmed with an additional further direction that the alienation of shares, further alienation of shares of Mr. Beer insofar as the beneficial interest of award debtor number 1 in Akash Educational Services would stand protected by an order of attachment in order which would only further the interim order passed on 1/9/2025. Needless to state, it's clarified that this is a provisional arrangement made for the time being and would be subject to final orders to be passed in IA 1/26. Issue notice on the IA to respondent number 3 and 4 as well. Respondent number 1 to file their statement of objections, if any, by the next date. Relist after 2 weeks.
Please.
Manoj, may I request your lordships to mention the number of shares, that 17 million. If that's mentioned, Manoj, then it will be clear.
Where do you get that?
Manoj, that
In
is
the IA schedule itself, my lord.
In the schedule itself.
IA 1 of 2025.
IA
1 of 2025, page 6, my lord, page 6. 17,891,000. Second line.
Yes, that is the number of shares.
Number of shares.
Those are the shares to be attached.
Attachment is of shares numbering 17,891,289.
Please. All the
Your Lordship, I had a memo to move in the morning, Your Lordship. I just got the FR number, so I'm filing it now. It's a special court matter.
22. 22ನೇ ತಾರೀಕು. Pass our matters. Next one, serial number 5, Senthil Kumar.
Well, it's counsel for the petitioner, my lords. Because this is an tax claim matter, my lords, writ petition. Because in this, the impugned order is annexure A and annexure B. That is what is sought to be squashed, my lords. Because annexure.
Just 1 minute.
Yes, my lords.
Yes, who's the authority? Central tax, is it?
Yes, my
Or
lords.
state?
1 minute, my lords. Yes, my lords. The Commissioner of Commercial Taxes is R2, Assistant Commissioner of Commercial Taxes R3 and R4.
Huh? State. Let them come, I'll just take it.
Yes,
up.
please, my lords.
As soon as they come, I'll take it up.
Yeah, please, my lords.
11, serial number 11, Prashant, yes.
Lords, 11 can be taken up with 65, my lords.
Ah, okay, pass. Yes.
26, serial number 26.
Go through. Now I made her argue for your benefit. So now you know what she has argued. So her synopsis is there. Before you argue, you must also file your synopsis. Reason why I insist on synopsis is to make sure that you are also ready. I don't want arguments to start and then say I'm not prepared. Now you have the benefit of her arguments. Neatly, she has given a synopsis. Have a look at it and get ready. Synopsis filed by the petitioner is taken on record. Relist the matter on that day. You must be ready. Yes.
Obliged.
And she's saying it's covered. So if Kusum ingots, it's covered.
Sal Steels.
Huh?
Sal Steels of Gujarat High Court.
Correct.
Yes, ma'am.
Kusum ingot says central legislation.
Yes, ma'am. Yes. Obliged.
Yes.
Party continuation 44, Sunil Kumar, yes. Madhukar.
In compliance of the order dated 1812, I visited AIMS on 6th, my lords.
44.
In page 1, I visited AIMS on 1st, 6/1/2026.
And this is their report.
The AIMS report, my lords. The doctors at AIMS have said me to get admitted for complete evaluation. Last bottom, my lords, needs admission for evaluation and management. And page number 2, my lords, regard to availability of the ward would be available only on 21/1/2026. So they've asked me to come again on 21/1/2026.
Okay, we'll take it on record. Everybody's praying for his health, including the ED.
In fact, my lords, have been yet taking treatment at ILBS also. On 5th, I was admitted at ILBS. I produced those records also.
Memo filed by the counsel for petitioner is taken on record. It is submitted that the authority at AIMS have observed that admission is required for evaluation and management, and that date has been fixed for admission on 21/1/2026, and they would
Subject to availability, my lords. 21/1/2026, subject to availability is what they have stated.
21/1/2026. Let us see. And that they would ensure that they would admit themselves at AIMS. Along with the memo, the medical records of Ames is annexed.
Medical records of ILBS.
Of
Ames and ILBS.
Ames and
ILBS, Institute of Liver and Biliary Sciences. ILBS.
ILBS is enclosed.
Is there any direction to Ames by your lordship on what the examination should cover?
Now, if you propose, if both of you would propose something which may have a bearing on how we are going to look at it once the report comes, you can place it, we'll make it a part of the order also. What we could do is now, of course, they're going to do a medical examination. But to what extent that is going to have an implication on his ability to move?
If Ames can clarify, if the nature of ailment that he is undergoing requires continual medical attention, or it is only periodical. For instance, if it is periodical.
We'll ask them to clarify.
No, would that be, would your lordships consider?
We could make an observation.
Yes, because on 21st, anyway, he'll be examined. Otherwise, they may simply say, these are the parameters. So as lawyers and judges, we will not be able to decipher what exactly it means. Ultimately, your lordships have to decide whether he can remain in custody or he requires continuous medical attention. This is what ultimately matters for grant of bail. So that observation, if it is made, then the doctors can accordingly render their medical opinion.
In that case, my lords, the doctor
will make that only an opinion.
Yes.
Apart from the test, we'll clarify it, that this will be an opinion which we are eliciting. We'll take a final call on that.
Yes.
In that case, my lords, the doctor whom I'm consulting should also give an opinion, because I've been regularly being treated from him.
Correct. We'll get whatever is required. We are not going to restrict it. Finally, whatever inputs we are going to take, we will have to take the final call.
Please, ma'am.
Apart from the medical examination, including his health parameters, in light of the context in which such opinion is sought, the concerned doctors may also touch upon the aspect of the petitioner, whether petitioner's treatment would require continuous hospitalization or could also be continued in custody with appropriate treatment. It's clarified that such aspect is only an opinion from the doctor of Ames and would be subject to the court taking a final call.
Precisely. I'm grateful.
Should the petitioner also produce the record with respect to the doctor from whom I am getting treated at ILBS, my lords?
Once the report comes, we will hear you. You are at liberty to give whatever it is. We have an open mind on this.
Interim bail to be extended.
In light of the same, the interim bail granted by the special court on 11/9/2025, which has been extended till date, is extended till the next date of hearing on same terms. First week, we'll have it in first week. By then, let the report come. Relist the matter. First week and date. Fifth.
Very good.
Yes. Correct.
45, then 46, 1H 46. Forty-six, 1H.
This is Harish one.
In this case, my lords, we had initiated proceedings
46
under
warning.
second schedule, my lords, for arrest of the defaulter, my lords. My lords, what had happened subsequently, they filed a writ petition and then given immovable property as security, my lords. My lords, now the original documents, my lords, are not with us. So we are not able to proceed with the auction. And my lords, they are not even appearing before your lordships from my lords.
No representation on behalf of the petitioner.
Lords, I request your lordships may allow us to proceed with the Lords, proceedings at Annexure A, my lords, to continue this. Because this is recovery proceedings, my lords, under the Income Tax Act.
But where is this stayed?
My lords, they had given an undertaking, my lords. So in view of the undertaking, my lords, we had not proceeded with arrest.
Land Council appearing for the Department Revenue. Sri Dilip submit. With the situation of the undertaking.
Please, my lords.
They would be constrained to proceed further. You appear, is it, madam? You appear?
Lord, I appear for the one of the petitioners earlier for whom I filed wakalat and application for transposing Lord, which was dismissed. Lord, and there by this honorable court. Thereafter, Lord, I have no information, no Lord, idea as to where the petition number 2 is.
Let us see. Let us.
Lords,
But you file your.
Initially, my lords, husband and wife, my lords, petitioner number 1 and 2 are husband and wife. My lords, they had given an undertaking. My lords, after undertaking, my lords, now the wife, my lords, has filed an application before your lordships for transposing her as a respondent. My lords, that was rejected, my lords.
No, correct. Now the undertaking is of the husband.
Both, my lords, both husband and wife.
Now, if you have no instructions, then you must file a memo of retirement, madam.
Lord, I'm trying to send a letter or communication to her before that, Lord, which I am unable to. Lord, I shall do that in a week's time.
Land Council for the petitioner number 2 further submits. Land Council for the petitioner number 2. She's the petitioner number 2.
Petitioner number 2, my lord. Subsequently, what had happened?
They wanted to transpose.
Please, my lord. After giving joint undertaking.
Respondent.
Please, my lord.
Council for respondent number 2 submits. Petitioner number 2 submits. There are no instructions from the second petitioner. Accordingly, for further orders and directions to be passed by this court, relist the matter same stage on 1 week admin time. 28. On that day we'll proceed.
Please.
Please.
47. Harsha D. Joshi.
Relist.
My lord. I'm seeking, my lord, a writ of mandamus as against, my lord, the KADB. The issue involves, my lord, a suit for partition. The claimants, my lord, are now before the SLAO, and they have, my lord, raised their objections, stating that, my lord, during the course of the suit, my lord, which is pending for partition, the amount shall not be dispersed. My lord, may kindly look into ink page 90, my lord. Ink page 90, my lord, is my representation. Let my lord, the SLAO, please, my lord.
Other side is not there. Pass over. If they come and take it up.
Please, my lord. Please.
48 urgent. 49 Arun KS.
Not in this case, I have sought for the petitioner has sought for the mandamus, writ of mandamus against the BBMP.
What is the clarification?
My lord, that IA, my lord, we are not pressing.
Then why is it come before me?
My lord, this is the second time it is happening. Earlier, my lord, this court has heard the matter.
No, that's okay.
Initially.
That's okay.
Last time also it has posted before the honorable court, and that day it could not reach the.
No, it should go before the regular roster.
In fact, my lord, we had moved a memo there, but it has been posted here.
List the matter before the regular roster bench. Date could.
Much obliged. Date maybe.
21st.
21st. Much obliged.
Should kindly have the date after 22nd, please.
27.
27.
After 22nd, I said. I have it on 24th.
After 20?
22nd.
The 27th, he said. 27th.
27th is fine.
27th. Much obliged.
One.
Now that IA for clarification will close it off. Why? That's why.
Please, Milord. It
Ah.
may be,
IA 3 of 25 is dismissed as not pressed.
Not pressed.
Just give up a memo.
Please, I'll
50, Darshan, or
For the petitioner in this matter, Milords. Milords, there was office objection with respect to the IAS. I've been served it to the GST Council, Milord. I have an acknowledgement too. This is with respect to amendment of prayer and one is for modification of bail condition, Milords.
Seeking for the modification of bail condition, my lords.
How has it come here?
Lord, this honorable court granted the bail. This is with respect to GST, Milords. WPGs,
No, how can
tax areas.
correct? But how can this?
Not been served with the copy also, my lords. I have only been served with the amendment application. They're seeking for the amendment of the prayer. That is how I got it.
I've clarified in another matter relating to arrest. It has to go before 482, WP 482 and bail. How can we do it? Arrest is arrest, GST or otherwise. What is the IA for modification?
Modification of bail condition, my lord.
Huh.
One is that is with respect to, there is one condition where the petitioner is not supposed to leave Bangalore jurisdiction. That is one of the condition, my lords.
Then let it go before the same bench.
Same.
IA 1 of
But
25.
they had filed a writ appeal challenging the writ petition filed by us. The honorable division bench remanded back the matter to the single bench judge, stating that whatever bail condition or with respect to the arrest procedure, they need to do a fresh consideration. This is what order wise in writ petition number 645 of 2025.
Serve it on him, let him have a look at it.
Please, Manoj.
Copies to be served on the other side. If it relates to an order passed by the other bench and bail has been granted and is seeking for modification, it will have to go before the same bench. Is it so or no?
No, ma'am. Honorable court mentioned that.
Okay, let us see. Have a look at it. Have a look at it.
Yes, ma'am.
Date.
51.
21. Not made posted on 21, my lord. 21st. Wait for me.
51. Vivek, yes?
No, this
Yes,
matter by the order
Balaji.
dated 6/11, my lords. DST had taken notice, my lords, but subsequently they said it does not come within their domain. So and subsequently we have served AG's office only, my lords.
My lords,
In
I'm
respect
for
of respondent number 3.
I'm for respondent number 4 and 5. We'll file our,
He accepts notice.
we'll file our objections.
Delete in the cause list the entry DSG for R3. Now pleadings are still to be completed. Pleadings are still to be completed.
Yes, ma'am.
State to respondents to file their statement of objections within 2 weeks. This is the matter thereafter.
52. Puneet C.
Well, I appear for the petitioner in the present case. The private respondents have filed wakalat. Their
R19
name is
and
not
19.
shown in the cause list.
Like today I filed up wakalat for our respondent number 19 and 20.
Now council so and so has filed wakalat for R
19 and 20, my lord.
R19 and
20. I'll file my
For other
objection
respondents
next.
also, they have filed wakalat.
Who else you have filed wakalat for?
19 and 20.
That's all.
That's all.
Now
Lord,
insofar as minors are concerned, you will
Please,
have to
Bharat.
file an application for appointment of guardian.
Yes, please, Bernard. I'll file an application.
Insofar as R17 and 18, petitioner to file application for appointment of guardian.
Lord, may I request one submission? May I make a request, my lord?
Yes.
My lord, there is a threat of alienation by the respondent number 19 and 20. May I make few submissions, please, my lord?
Now you will have to
I'll
take
file
your,
my objection, my lord.
you'll have to take your stand.
Yes.
I'll give you a
Today I
short
have
date.
filed
On that date, you must be ready. Now that you've
My lord,
entered.
here, my lord, kindly for a moment, kindly peruse annexure A for a moment.
No, we'll pass an order. I'll have it next week. Next week, we'll pass an order.
Same stage, if I may request, my lord.
Yes. Relist.
My lord, in respect of respondent number 4, my lord.
Same stage.
In respect of respondent number 4, my lord, the MODA only appear, my lord. MODA panel council will be appear, my lord.
R4.
R4, my
lord.
Vivekananda idara.
ಅಲ್ಲ ಇಲ್ಲಿ ವಿವೇಕಾನಂದ ಇದೆ ಬಟ್ ವಕಾಲತ್ತು ಜಿ ಬಿ ಶರತ್ ಗೌಡ್ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಶರತ್ ಗೌಡ ಶರತ್ ಗೌಡ.
Whoever appears, yeah. Wakalat is filed.
Wakalat filed by Sharath Gowda.
Filed.
But ಇಲ್ಲ ವಿವೇಕಾನಂದ ಅಂತಿದೆ ಅವರೇ ನಾವು ಹೇಳ್ತೇವೆ.
No, who has filed Wakalat for R2?
ಅಲ್ಲ ಜಿ ಬಿ ಶರತ್ ಗೌಡ has filed ವಕಾಲತ್. I checked in the e-courts mobile app.
So then let it come. Office 2.
Yes.
Show the name of learned counsel G.B. Sharath Gowda as representing respondent 2 and 3 and strike out
and 4.
Strike out the name of learned counsel T.P. Vivekananda. Counsel from MUDA is directed to accept notice for R4 as well.
Please.
Interim order to continue, my lord, not to dispose ಇದೆ.
Interim order earlier grant is extended till the next day. List on. Yes.
53.
Please.
The court has been paid. Seeking for writ of mandamus to to consider the representation as for unnecessary FNG. Payment of compensation, my lord.
Court fee you have paid.
I have paid today.
So who appears for the respondent?
My lord,
MUDA,
my lord, Commissioner and the SLG. I will serve the copy, my lord, from the panel advocate. R2 and R3.
MUDA.
Which is to be added, my lord.
No, you have challenged the final notification.
My lord, I concede, my lord, only with respect to the mandamus, my lord, prayer B, my lord. I will not press, my lord, prayer A.
File a memo.
Please.
Petitioner is restricting his prayer to prayer B and C and does not press as regards prayer A. In light of the memo, the prayer in the present petition is to be construed as being limited to prayer B and C. Learned counsel, Manjuna. G.B. Sharath Gowda is directed to accept notice for respondent 2 and 3 AGA for first respondent. Relist the matter in the preliminary hearing list.
Please.
Only on that, isn't it?
9th.
Yes.
9th of February.
9th of 54 and 55. Abhishek, yeah.
I undertake to file wakalat for R1 my lords. We are disabled before this court, my lords. R1. Shruti Chan.
Learned counsel so and so undertakes to file wakalat for
R1 my lords.
R1.
One submission, my lords. Also, with respect to R2, I beg to appear for the petitioners. There's already wakalat filed on behalf of R3. R2 is none other than the wife of R3. So the same counsel may be directed to take notice.
That we'll see.
Please.
Not before me, list before appropriate bench after obtaining orders.
Interim orders may kindly be continued.
Interim orders in operation are continued till the next day. Yes.
Grateful.
56. Number.
That's for the petitioner, my lords.
Writ challenging the order passed under 129 and 107 of the CGST Act, my lords. If I may brief my lords about the facts, my lords. On 13/5/2022, my lords, the goods were dispatched from my warehouse, wherein I had generated tax invoice, my lords. E-way bill was.
Nature of a second appeal against an order passed by the first appellate authority. I'll have to complete the pleadings and the matter will have to be heard on merits. They have paid the penalty and 189(1)(a and got the vehicles released. Penalty order was passed in 2022.
Pleadings to be completed by the respondents within 4 weeks.
Please.
This is the matter thereafter. Yes.
May I request for a specific date, my lords?
Date.
17th of February.
Oblige, my lords.
57.
For the petitioner's lordship. Served a copy of the petition to all the respondents. Also filed the memo with the acknowledgement.
You have served.
Yes, your lordship.
4, 8 and 10 still to be served.
Your lordship, we have served it. We filed the memo with the acknowledgement this morning as well.
They're private respondents, is it?
4, 8 and 7.
4, 8 and 10.
Your lordship, respondent number 4 is the additional chief secretary UDD. 8 is Karnataka Groundwater Authority.
AG accepts notice for 4th respondent. 8 is
Karnataka Groundwater Authority.
Yes, AGA.
Groundwater case. Karnataka Groundwater Authority, my lord. It's a private authority, my lord.
Then 10.
10 is your lordship a private body, MS Skyline Developers.
Office to put up a report regarding notice issued to R10. Released week after next.
A date may be fixed, your lordship.
Date.
16th of February.
16th of February. Obliged.
58. Naveen Jayan.
That's week's time may be given.
Time granted to take necessary steps for unserved respondent.
59. Akash Viti.
59. I appear for petitioner in this matter, my lords. It is await notice as far as respondent number 4 is concerned.
Office to put up report regarding notice issued to R4.
Interim order may be extended.
Interim order operation extended till the next date.
60. Sharath Yaskauda. 60.
Office to put up report regarding notice issued to R4. A1 of 25 is allowed petitioner dispense with production of certified copy of annexure G, A and B. The interim order is extended till the next date. Yes.
61. Muhammad Ishaq.
Appearing for the petitioner, your lordship. The office objection number 2, the prayer and interim prayer is mentioned in the affidavit, your lordship. We made a submission, it may be overruled, your lordship. And objection number 6, your lordship.
Objection number 2.
2, your lordship.
What is 2?
2 is, lordship, in affidavit, prayer and interim prayer has been mentioned. So it has to be clarified and we made a submission, your lordship. So same what which is mentioned in the petition, also mentioned in the affidavit, your lordship. That's the objection.
Office objection at number 2 is kept in abeyance for the present. Then
office objection number 6, your lordship.
Yes.
It is, we came to know that our land is to be, its respondents going to acquire by the respondent sides, they installed the bricks, your lordship, which is yellow color tape. And my neighbor properties already they have been encroached. Acquirization is, everything is completed. In my property, your lordship, site number 6 and 7, I have produced the photographs, your lordship, in annexure A. Kindly peruse the annexure A.
What is the office objection?
Office objection is, lordship, the notification of the order or notification regarding the site number 6 and 7, which the respondent is going to the acquire, your lordship. We came to know that our site is going to be acquired by the respondent sides. They install the bricks to acquire the property, your lordship.
Office objection at C number 6 kept in abeyance for the present. What else? But if you are going to seek for setting aside of acquisition notification, you have to file it.
Yes.
What happened, your lordship? We produced the photographs, your lordship. And even though in annexure K, your lordship, we gave the request letter to the concerned authority, your lordship. Till now, in 2024, we gave the request letter. Till now, there is no reply from their side, your lordship. Even though we go there, the harsh.
Let us see. Now the other office objection you have to comply.
It has been completed, your lordship. Everything needful done.
Removed annexure I.
Removed annexure I. Everything is needful is done, your lordship. Office objection 2 and 6 was pending. It has been submitted.
Other office objections have been complied with. Office to verify.
And interim order may be extended.
Interim order is extended till the next date.
Great for lordship.
62.
Appearing for the petitioner in this matter, my lords. May I submit, my lords?
Yes.
The challenge, my lords, is to the assessment order and all the consequential notices and orders. Lordship may kindly for a moment take to the assessment order at annexure H1 at page 148, my lords.
Is what your instruction, Dilip?
Malaj, Lordship, can you have next week, Malaj? I could not do it.
Huh?
Next, Malaj, Tuesday it can be taken.
Tuesday.
Please.
No, there is
Malaj,
there is a threat of recovery in this case, my lords.
Malaj, they've raised, Malaj, the assessment order passed is beyond time is what one of the ground. Lordship, may kindly and show cause notice, Malaj, is different from the assessment order is a second ground, Malaj. Lordship, may kindly have it next week, Malaj. Malaj, in the same state.
My lords may kindly hear me for a moment so that I can make out my ground for interim prayer, my lords. Because
So
there is a threat of recovery in this case.
If anything happens between now and Tuesday, I'll pass appropriate orders. It's made clear that as interim order is still to be considered, any action taken by the respondents.
May I just make out my submission in 2 minutes, my lord, because the assessment order is clearly time barred. I can demonstrate that before this court.
Till next week, Malaj, I would, there won't be any recovery, Malaj. It can be taken up on Tuesday.
Learned counsel for the respondent submits.
Malaj, Lordship may kindly not record, Malaj. I'll inform them, Malaj, orally.
Would be subject to orders to be passed. Relist the matter on Tuesday in the same stage.
Lordship may take it into fresh matters, my lord, it may reach in the first half. Because it has come under orders at the end of the list.
62 and 97, Malaj, are same connected matter. Same assessing, Malaj.
Just in preliminary hearing list.
Please, my lords.
List along with
item 97. 97.
And list along with field number 97.
Oblige, my lords.
63, B. Vachan. For the petitioner.
For the respondent, your lordship, you have filed a wakalat today. You seek time to file objections on same.
Yes, sir.
Third count. So submits that wakalat has been filed on behalf of respondent number.
Only one respondent, Kumar.
Sole respondent.
Sole respondent.
Sole respondent. Relist date good.
Interim order may kindly be extended.
Interim order in operation extended to the next day.
64. Harish.
First, this is a matter where the adjudication order is passed merely based on the expenditure turnover that is shown in my financial statement, which is prepared for a consolidated basis, my lord. The expenditures reflecting in my financial statement or the profit and loss account is based on a pan-India basis turnover. Instead of segregating only to the extent of Karnataka registration, the respondents have gone beyond the Karnataka jurisdiction and have considered the turnover pertaining to the other states as well and arrived at the demand. So the demand is entirely on the reverse charge, the RCM liability, my lords. I have also sought time to produce the segregated financial statement pertaining to Karnataka, but which they, without considering my submissions, they have passed the order.
Is there any reference to that submission of yours?
My lords, I would like to take my lords' attention to the show cause notice where they are accepting that because there is no documentary evidence, they are considering the pan-India based turnover. Page 76 minutes. 75, 76 minutes. Under page 75, they have provided the line item wise expenditure liable to RCM. Next page 76, verification of the above details related to RCM. It is observed that the details available in the financial statements based on pan-India statics, but the taxable person denied to produce classification of financial statement related to Karnataka transactions. Therefore, the above details considered as the transactions related to Karnataka and proposed a RCM liability in the observations issued from this office, but the taxable person did not produce any objections or classification of RCM liability along with vouchers, invoices, day book accordingly. To this, I have replied, my lord, in page 81 onwards. There was also a personal hearing. I appeared. I sought time. Page 83, my lords.
No, but now, do you have, as of now, the details of Karnataka?
My lords, I can produce the details of Karnataka. I have also filed an IA with the details. If an opportunity is given, I can explain the pertaining to Karnataka registration, and then they can consider.
My lord, they would have went for alternative remedy, my lord, appeal remedy. They didn't avail the appeal remedy. They waited long, and they directly approached before this honorable to escape the pay the 10% of the demand. By paying just 100 rupees, they want to take the relief, one thing. And delay, who has to condone the delay? Where they have a right to claim the delay, my lord?
My lord,
they're purposefully to drag the matter. They did like this, my lord. I will file statement of objection.
The correct, just what their submission is that the financial statements based on pan-India statistics has been taken.
My lord, they have produced the books of account, half of the books of account. They have not produced the books of account fully. We have cooperated. We have given several dates to produce the documents. They constantly sought the time. They don't have a documents at all till now also.
No, I am ready to produce now.
Produce it. Then let them. They'll take a call. You produce.
Let them produce, my lord. Maybe this honorable court may be directed now only before this honorable court.
Produce.
I'll verify if reasonable we can believe means. Then I will seek instruction manual.
Fair submission. You give the Karnataka breakup.
I will do
you
that.
Produce it. Let them take instructions.
I will do that.
The counsel for the petitioner submits that the assessment proceedings are concluded on the basis of financial statements relating to pan-India statistics, and that the petitioner has details including financial statements relating to the transactions within the state of Karnataka, which must be taken note of. Full stop. To demonstrate bona fides, petitioner to produce financial statements relating to transactions within state of Karnataka by the next date. Relist.
Much.
10th of February.
Much.
65. Connected matters.
Please, Milords. I think all of them have, multiple people have taken notices in all of these matters, my lords, but I think all of them are aware of the issue.
Meetings are completed.
For the serial number 11, my lords, a fresh matter, but it is the coordinate bench has relied on the 9610 proceedings across various courts and the omission notification that has happened. I'll run my lords through that. 89-4, my lords, that batch of 65, I think one matter pleadings have been complete, my lords. The matter that is 65.
Now, are you ready now? Who appears for the department?
My lord,
In one case,
my lord.
I appear for respondent 1, 3, and 4, my lords. And pleadings are not complete. In this matter, they have availed the input grade, suppressing the material facts, and that has been called out in the show cause notice, page number 134.
No, correct. Now you want to file pleadings or adopt?
Yes, ma'am.
Filed by
Yes, ma'am. Some chat.
in the other.
65.3, I am appearing for first respondent.
No, you want to file something? I'll fix a date.
Yes, certainly, ma'am. We would like to file the objections. Short accommodation will be granted, my lords.
I'll take 5 minutes. I'll just explain the entire scenario of what has happened and transpired in this entire issue. My lords may remember there was this batch of 9610, rule 9610, that had been challenged in a batch of 20 matters. It had been challenged. Serial number 11, my lords, is on rule 9610.
What is this 96?
I'll just point my lords to, there is a small compilation along with the list of dates and events that I can pass on. Lords, the assessees before my lords are either export-oriented units or have something known as an advanced authorizations. Essentially, my lords, these are all people who export certain goods or services out of India. My lords had the opportunity when I had mentioned when I export goods or services outside of India, I'm eligible to claim refund of all the ITC that can be claimed by me that I've used for the purposes of export of goods or services, my lords. Now, post 2017, after GST was introduced, my lords, there were two provisions under which I could file a refund claim. One is something known as a Rule 54. The other is something known as a Rule 89.4. Now, 89.4 had a formula by which I could figure out and give a proper number as to what is the total amount of ITC that has been used for the purposes of export, and basis that formula, I file my refund application, my lords. My lords, may have this this chart of list of dates and events, my lords. Now in 2018, I have this chart, my lords. In 2018, my lords, they bring in two rules. Two rules they substituted. One is Rule 9610. The other is Rule 89.4b. Now, what they intended to do with these rules, my lords, was this. If as an exporter, my lords, if I have claimed a benefit of any other notification, then I was barred from claiming refunds of all of these inputs that I have claimed. So 9610 was one rule where it said that all advance authorization, if I have claimed any benefits of any other notification, then I will not be entitled to any kind of refund. So that is one set of matters. The second set of matters, my lords, was 89.4b, where it was tweaked to say that I have to do a one-to-one correlation between whatever inputs I have claimed versus the exports that I was doing. My lords may then have 9/9/2024. There were two sets of batches that traveled to different courts. One set of matters which originated with Karnataka High Court was the 9610 batch. About 20 matters were disposed of by the coordinate bench pre-vacations. The other batch was, my lords, the 89.4b batch. That is this 65, my lords. Now, what happened, my lords, was this. The GST Council realized that there is a problem with both these rules, both 9610 and 89.4b. The first matter, my lords, was this Kerala High Court matter, last row, my lords, 10/10/2024 in this list of dates or events.
This is the list of dates, isn't it?
This, my lords, we've just passed on a detailed I'll just run, my lords, again through that. 2018 were the two substitutions, 9/10/2018. And then, my lords, 9/9/2024 was the GST Council meeting. I'll take my this compilation has all of these minutes also. Now, what happened, my lords, on 10/10/2024, Kerala High Court first said 9610 is ultra virus. At the same time, the GST Council omitted both 9610 and 89.4b by way of a notification in 2024. That the Kerala High Court recognized in their judgment, and they said that this 9610, only 9610 was challenged in Kerala High Court. 9610 is ultra virus with retrospective effect. Now, basis this, my lords, what happened was 4 division benches of various high courts: Bombay, Uttarakhand, Gujarat, Delhi. 4 division benches of various high courts held that we will not get into the constitutional validity of 9610 at all, because science has already addressed this problem. So therefore, basis Kusum ingots, ultra virus all across the board. They go one step further. The notification that was released in 2024, omitting both 9610 and 89.4, did not have a repeals and savings clause. So what all these 4 division benches of the Bombay of all of these high courts did was, they said, since it did not have a repeals and savings clause protecting the earlier proceedings that were all initiated between 2018 and 2024, all show cause notices, orders, investigation, etc. are set aside. All refunds can be processed. Now, this happened in the Karnataka High Court as well. The coordinate bench, my lords, in this compilation that I've circulated, my lords may have page number 131. The coordinate bench, relying on all of these judgments, disposed of the entire batch in favor of the assessees. Therefore, my lord, serial number 11 can be disposed of in line with this
judgment of the coordinate bench, my lords. My lords may have the entire reasoning that my lords has. My lord may have para number 3 onwards. Page number 134, my lords. In addition to reiterating the various contentions urged in the petition and referring to the material on record, learned senior counsel for the petitioner invited my attention to the impugned show cause notice issued by the respondent number 5 in order to point out that the said show cause notice was issued pursuant to the notification dated so and so, under which 9610 was inserted into the CGST Act by way of amendment dated so and so. It is submitted that the validity of the said notification was challenged before the Kerala High Court in so and so, wherein the said rule 9610 was struck down as unconstitutional with a order dated 10/10/2024. It is submitted that prior to striking down of the said rule 9610 on 10/10/2024, the respondent had already omitted the said rule by issuing a notification dated 8/10/2024, which was noticed by the Kerala High Court in the said order, which proceeded to declare that all proceedings between 23/10/2017 and 8/10/2024 would stand abated and deserve to be quashed. Now, my lords, the coordinate bench extracts all the division bench orders of various high courts, my lords. My lords may have, just pertinently, my lords, the Bombay High Court extractment, which is there at page number 160. I'll take my lords separately to the Bombay High Court decision as well, because the Bombay High Court decision also covers 89(4)(b), which my learned friend pointed out. Para 117 at the bottom, my lords, of the Bombay High Court decision. This is the argument about the impugned show cause notices being issued under section 73 of the CGST Act and such notices surviving because this section had not been omitted or relieved also cannot be accepted. The only allegation in the impugned show cause notices concerned the alleged violation of the requirements of the impugned rules. There are no other allegations as was asserted by the learned counsel for the petitioner and not disputed by the learned counsel for the respondent, though specific opportunity was granted to them. Therefore, if the impugned rules are omitted or repealed without any savings clauses or the protection of section 6 of the General Causes Act, nothing would survive in such notices. Such notices cannot be saved based on the argument now advanced. The finding, my lord, is from 122. Upon comprehensive review of all of the above aspects, we hold the following omission or repeal of the impugned rules, i.e. 89(4)(b) and 9610 of the CGST rules via notification dated October 8, 2024, and in absence of any saving clause or the benefit of section 6 of the General Causes Act, all pending proceedings such as indisposed show cause notices, orders disposing of show cause notices issued after 8th October 2024, or even orders made before 8th October 2024 but not yet finalized due to appeals before the appellate authorities or challenges before this court, thus not constituting transactions passed and closed, are not preserved and will stand lapsed. Accordingly, we quash and set aside the impugned show cause notices, and thereafter, my lord, the coordinate bench follows its own order in the 9610 batch, my lords. So serial number 11 can go basis because serial number 11 has been held ultra vires, my lords. Now the problem for 89(4)(b), my lords, is no court has held 89(4)(b) to be ultra vires. But because there is an omission that has happened in 2024 and because there is no repeals and savings clause, Bombay High Court is the only division bench that says that because there is no omission as part of the 89(4)(b), all the pending proceedings also will go. Therefore, 65 also, my lords, in my respectful submission, basis the Bombay High Court decision also, all these matters can be disposed of.
My lord, just one more submission. My lord, 65.4 is directly covered by this coordinate bench. The rule 89 is not invoked in there. It is just covered by 9610 judgment of this honorable court, my lords. 65.4.
Now, revenue. Now, if that is the position that there's an omission with no savings clause, and that's what the coordinate bench have held, what follows must follow.
Yes, my lord, serial number 11. I would agree with my learned friend, but only thing is that it has come up first today. My lord. New notice is not issued.
We'll keep that separately.
Yeah, please, my lord. And the date can be fixed any day, next week or a week after next.
Serial number 11.
I'll just
yes,
inform the department, and then in respect of serial number 65, my lord, I'm not appearing. My learned friend Uni Krishnan is appearing.
Serial number 11, let it be separate, let's see if that.
Very well, Manoj. The reason why I wanted to tag both these matters was because it's the same notification that omits both the rules. That's the only reason I said we can take both the matters up together.
Strategically, let one be disposed, then the rest we'll see.
Serial number directly comes under this judgment.
11.
Take notice, my lord.
11. Counsel Arvind Chavan accepts notice for the respondents. List the matter in the preliminary hearing list on
Tuesday.
28.
28th.
28. My lord, I think there are multiple respondents. My lords, the cost title is at page number 19. I think State of Karnataka also is a party, my lords. Union of India, State of Karnataka, I think 3, 4, 5 and 1. 6. 1, 3. So I think sir will appear in 1.
My lord, serial number 1, Mr. Madan Pillai.
Madan Pillai for
Serial number 2, state, my lord.
R1.
3, 4, 5.
AGA for second respondent. Arvind Chavan for 3, 4 and 5. This is the matter in the preliminary hearing list on
28. Third. Okay. Third very well, Manoj.
On
3rd of February.
3rd of February.
3-2.
Now, in the
Once-
other matters,
Serial number 65.1, my lords. 65.1.
yeah,
Well, I'll seek 2 weeks' time. Minutes may be taken up. First week of February, I'll also take instructions and place it on record. Any objections to be filed by the time.
I'll have it on the same day,
Yes, sir.
on 2nd of February.
Update.
Third of February.
3rd of February.
Manoj, just one request. 65.4 can be detagged from this batch. It's not a Rule 89 issue, my lords. It's directly a 9610 issue, which is covered by this honorable court's judgment.
That can be maybe
Along with 11.
11 can be tagged, my lords.
Yeah. Yes, my lords.
65.4 is to be delinked and listed along with serial number 11.
Yes, my lord.
Lord, serial number 11, a stay may be required, my lords. It's an order in appeal.
11 kudu.
11.
In light of the contention of the petitioner that by virtue of the order passed in
writ petition number 15251 of 2020.
15251 of
2020.
The present petition is also to be allowed by taking note of the observations therein. There would be stay of
Annexure C, my lords, page 76.
yes, C. Yes.
I'm grateful. My lords, the stay in serial number 65 may be extended.
The interim order in operation 65 to be extended till the next date. Relist the matter on 3rd of February.
My lords, in 65.4, notice should be issued, my lords. Notice has not been issued in 65.4 separately.
No, they're appearing.
Okay, ma'am. Obliged, my lords.
66, Kusuma M.
Appeal for the petitioner in this case, my lordship. Matter is covered by judgment, my lordship.
Yeah, before respondents, it's correct, no? It's covered by. It's
Covered.
correct, no? Submission is correct.
This
Could be disposed of based on the coordinate bench order.
Representing my senior name may be difficult. Punam.
Covered by which order?
Annexure D, my lordship, page number 16.
Page
16.
16.
Yes, my lordship.
No. ಯಾವ್ದಿದು? Which page?
Page number 16, my lordship. Page number 16, Annexure D.
Yes. Yes. Which paragraph?
This is the case where preliminary notification alone was published, not followed by final notification. It was para 3, my lords.
Now your final notification is not issued.
Yes, my lords. Even in this writ petition as well.
When was the preliminary notification issued?
It's on 28/6/2016. Same preliminary notification also was subject matter of question in the other writ petition which is relied on it.
Yes, yes. The petitioner has called in question has sought for setting aside of the preliminary notification dated 28/6/2016, copy of which is produced at Annexure A. An alternative relief is sought by the petitioner, whereby the petitioner sought for issuance of a declaration declaring that the land acquisition proceedings initiated by issuance of preliminary notification dated 28/6/2016 has lapsed by virtue of coming into force of the right to fair compensation and transparency in Land Acquisition Rehabilitation Resettlement Act 2013 insofar as scheduled land belonging to the petitioners is concerned. Full stop. Petitioner submits that the preliminary notification was dated 28/6/2016. Until date, no further proceedings have been taken to carry the acquisition proceedings to a logical finality. It submitted that in similar circumstances where preliminary notification dated 28/6/2016 was passed and no further steps were taken, the court has granted relief to the landowners in WP 19457 of 2023, and same relief may be granted in the present matter also. That is the order passed in WP 19457 of 2023. Order reads as follows. Next, taking note that in the present case as well, the acquisition proceedings called in question relate to the same preliminary notification, and admittedly, as no further steps have been taken thereafter by the authority, it would be appropriate on the principle of parity to extend the same relief as granted in WP 19457 of 2023. Taking note of the observations made above, the petition is allowed. Preliminary notification dated 28/6/2016 is quashed insofar as the property of the petitioner in survey number 9/5 measuring 0.31 guntas of Ballahalli village, Jaipura Hubli, Mysore Taluk. Yes.
Great.
Mobile microphone.
List 2, serial number 1, Hemant Kumar D.
Your Lordship, the SPP is just coming.
We'll start. You just make notes.
May I make a request before the senior starts? Serial number 68.
Yes.
My learned friend wants to withdraw the writ petition.
The petitioner files a memo
with liberty.
Which reads as here under. Later, same petition is dismissed. Liberty as sought for is reserved. All contentions are kept open.
Oblige, please.
Your Honor, serial number 81, there is a bunch of matters. It's already covered by the coordinate bench. Your Honor's
serial number
81.
Covered.
Covered matter.
81, I appear for.
Is it covered?
I have filed my objections, my lord.
Pleadings are complete in all the cases, Your Honors. There is an interim stay.
List the matter in the preliminary hearing list on 20th.
Much obliged.
My lord, serial number.
My lord, 67 is covered by judgment.
69, my lord. Lord, in that matter, that was regarding that cancellation of registration, my lord. Only there was a cryptic note of others. Lordship had directed me to take notice. I have taken instructions. They say that they require some more time. It was on based on some investigation. If Lordship kindly grant me 2 weeks time, I'll complete the pleadings. It may be taken up in the preliminary hearing and disposed of.
My lord, I appear for the petitioner, my lord, for serial number 69, my lord.
Let them complete the instruction. We'll have it on the next date. The preliminary hearing list. Preliminary hearing list itself will take it up.
Please.
My lord, date may be fixed, my lord.
List the matter in the preliminary hearing list on
4th of February.
Yes. Serial number 87, Your Worship. 5 of passed over, my lords. The counsel for the state is here.
I need to file statement of objection, my lord, because they have a beyond condemnable delay by the first appellate authority. Tribunal is not yet formed, my lord. I need to file statement of objection.
My lordship, serial number 67.
Just 1 minute. HCGP accepts notice for the respondents.
Number 12.
1 to 4.
Yes, ma'am.
1 to 4.
3 to.
So we'll have it week after next. Let us see.
Yes, my lords, please. As it is.
Released week after next. Other matters dates will be given by the court officer.
78.
Dates will be given by the court officer. You can collect
Serial number 8.
Wherever matters have not reached, interim orders are there, it will stand extended. Dates will be given by the court officer.
Yes, please. Your Worship, serial number 87. That is only mandamus, Your Worship. Consider my representation.
The mandamus, the preliminary hearing list.
Serial number 70.
Serial number 87.
Serial number 78 also.
Preliminary hearing list at the date.
Serial number 83, my lords.
Dates will be given you.
May be listed in preliminary hearing, my lords, for consideration of hearing, interim prayer.
They are trying to farm road in the middle of my.
I've stated.
Let's for consideration of interim prayer. It's serial number 83.
Orders listed.
83, my lords. It's.
Lord, serial number 75, my lord, it is
83.
called by the order of the coordinate bench.
Let us see.
Your Honor,
You make a request, dates will be given.
orders to be extended, Your Honor.
Wherever interim orders are, it will stand
Serial
extended.
number 75.
May I make a mention, my lords? List 2, serial number 3, my lords, was listed today for consideration of entry prayer that Arekanat, where my goods had to be released.
My lord, I will file statement of objection, my lord. They are relying the previous coordinate bench judgment, my lord, which will not applicable in this case, my lord. In that judgment also we are going already appeal. We are moving for appeal. And in this case specifically, it will not applicable, my lord. Facts of the case. It's a clear cut case of.
That I'll hear. If objection is required, I'll adjourn it. In so far, the interim prayer.
I have today I have received paravise remarks, my lord. I will file statement of objection.
Okay, so far the interim prayer.
My lords, I'm ready to deposit 200% of the penalty and give an indemnity bond, my lords. Let the
My lord, in this case, my lord, serial number 2, my lord, respondent number 5, I will undertake to file wakalat, my lord.
Which
List number 2, serial number 2.
Sir, see, list number 2, serial number 3 is going on. Please have some.
No, now there is some not to take further precipitative
My lord,
steps.
it is a case related to procedure of the law, my lord.
Okay, just 1 minute.
Yes, ma'am.
I'll have it tomorrow in the preliminary hearing list and we'll hear the matter.
So I'll just pass on one decision, my lords, which
Otherwise, I'll pass over, you take a chance. I don't have any other matters apart from this parted matter. You want to take a chance? I'll pass over.
My lord, tomorrow, ma'am.
Yes, give.
So,
Put it.
there are n number of decisions on this point, my lords, which says that once you initiate proceedings under 129, you ought to finish 129 and then proceed to 130, my lords. Honorable Andhra Pradesh High Court Division Bench, same issue, my lords. If I may request my lords to kindly take para 2, my lords. Apart from this, the petitioner contends the authorities were required to issue a notice under 129(3) within 7 days of seizure for calling upon the owner of the goods to participate in an inquiry to ascertain the tax payable. And the authority is required to issue a 7 days notice for issuance of notice to complete the process of valuation and determination of. In the present case, the goods were seized on 17/4, whereas no notice has been issued till date. Same set of facts even in my case, my lords. And further also they say, my lords, the petitioner contends that the authority, instead of completing the process under 129, has moved up to take the process under 130, and the same is impermissible. If I may request my lords to kindly take para 6, my lords. In last two, the goods of the petitioner would be released in accordance with 129(1). The proceedings under 130 shall be initiated only after this process has been completed. 129 opens with a non-obstacle clause, my lords, whereby 129 has to be completed, then only 130 has to be proceeded. In my case, my goods were seized on 27 November, my lords. They issue a 130 notice on 28th of December after lapse of 1 month.
Tomorrow in the preliminary hearing list. Tomorrow in the preliminary hearing list. You have a look at this. The court,
Just now I have received.
have a look at it.
I will.
The division bench appears to have stated the 130 can be initiated only after completion of 129. Have a look at it.
Obliged, my lords.
Serial number 1, list 2, Hemant Kumar.
Before I take this honorable court through the rejection order of the anticipatory bail, my lords, I'll first complete the sequence as per the synopsis, my lords. But then the synopsis would be out of the way. My lords, in the synopsis, serial number 37, my lords, just about 4 or 5 dates left. Serial number 37. It's at page 17. 19/12/2025. My lords may recollect, my lords, along with the writ petition order, the order was also passed on my petition under 482, which I withdrew with liberty. My lords, this order is at page 117, my lords. And just as a recollection, my lords, throughout our submission was, we want to be part of the investigation. We don't want to make it appear that we're trying to run away from the investigation or not wanting to not cooperate with the investigation. This was my submission, while throughout, my lords, in the 482, I said we will withdraw it with liberty. And my lords would permit the withdrawal with liberty as per the memo, my lords. My lords would get that at page 118. My lords, thereafter, on the next day is where we filed our anticipatory bail in the court below. My lords, serial number 38, 2012-2025. The fact, my lords, that the very next day we approached the lower court, because, my lords, one of the aspects for consideration is, were we trying to avoid any arrest at any point of time? Now, when a liberty is granted by the higher court, and on the very next day you go to the court below, virtually your anticipatory bail is before the court, my lords. So on the next day itself, my lords, on 2012-2025, was criminal miscellaneous filed before the lower court. The serial number 39 would assume a lot of importance, my lords. When the anticipatory bail was pending before the lower court on 22/12/2025, the CID files charge sheet as against 18 accused, reserving liberty to file charge sheet against A5 and A20. This charge sheet which was filed, my lords, was running to more than about 4,000 pages in 13 volumes. Now, what would be the effect, my lords, of not naming the petitioner in the charge sheet, or not even pointing out that at present we're not proceeding against the petitioner? I will come to it in a little while, my lords. A 5 months investigation that takes place, and you choose not to file a charge sheet against certain accused, and you file charge sheet against the remaining accused while reserving your liberty. What would be the effect of that? In my respectful submission, my lords, when we see how the CRPC is structured, my lords, and how an investigation has to take place, it is only post this investigation you would file the charge sheet. That would be under section 173(2) of the CRPC, my lords. Now, thereafter, my lords, if the investigating officer would discover some new evidence, then, my lords, comes the concept of supplementary charge sheet under 173(8). So I will point it out based on judgments, my lords, the effect of saying we are not going to be filing the charge sheet now, but we are reserving liberty. Now, my lords, of this charge sheet material, what was made available to the court was book 1 and book 10 of the charge sheet. Book 1 and book 10 of the charge sheet. Let's, once investigation is over and charge sheet is filed, my lords, in law, unless cognizance is taken, the concept of giving free copies to the accused doesn't arise till the cognizance is taken, my lords. But for the purpose of investigation, my lords, investigation gets completed when you file the charge sheet before the court. Therefore, my lords, though I made a request yesterday, it was strongly opposed to. Once you have completed an investigation and filed the charge sheet before the court, there would be no harm if a copy of it is made available for us to know on what basis you have chosen not to array me as an accused, or what is it that is there in your investigation papers against me.
Because the investigation not been completed.
Anyway, my lord, this is my submission. They can have their reply. So, my lords, the court had the benefit of 2 volumes of the charge sheet material, book 1 and book 10. And then, my lords, the court, by order dated 23/12/2025, was pleased to dismiss the anticipatory bail. My lords, I'll come to this order after I finish the sequence, my lords. The very next day, my lords, on 24th, is when we approach this honorable court, seeking anticipatory bail with the interim anticipatory bail application. 24/12/2025. My lords, on 26/12/2025 was a consideration of the interim anticipatory bail. My lords, I will not get into reading that order again because I had read the order before. My lords felt there was actually no such tearing hurry, but anyway, I will not get into it since we are arguing the main matter itself, my lords. My lords, this is the whole sequence that has taken place, my lords, even after my lord's order on 19/12. The only additional aspect is, my lords, as against my lord's order passed in the writ petition, allowing the writ petition, the state is now before the Supreme Court. In fact, the matter was posted at serial number 10 today before the Supreme Court, but the state has circulated a letter seeking time on the ground that I think the council was not available today. it's probably gone to next week, my lords. This is where we stand insofar as the SLP is also concerned. Now, my lords, when there's an allegation, that there is a person who is behind this act of committing murder. Now, he's not an assailant, but at his instance, a crime has been committed. If that is the allegation, from what I gather on how they want to go about it. So then the case against that particular accused is going to be one of circumstantial evidence, my lords. So when we look at what are the circumstances that ought to be normally seen by an investigating officer if he is going to be sustaining an allegation saying X was behind the murder being caused, there are about 9 circumstances of relevance, my lords. The first circumstance would be a motive, the cause for which the crime is committed, the motive, my lords. That's the first circumstance that we see. Now, post the motive, the second circumstance would be, my lords, if it is more than one accused, then it would be a case of conspiracy. Second aspect would be establishment of conspiracy through the materials that you gather. Now, my lords, normally when there are many accused involved, we would see, my lords, they would be what is shown as the main person who wanted it to be done. They call them kingpin, my lords, in more colloquial language. Then we would have the middlemen, my lords, who would make this arrangement of how it has to be done. Then we will also have the actual assailants. Now, if it is a case of Supari killing, so the actual assailants who carry out the act. Then we may also have persons who harbor later. So this would be the set of persons that typically we find, my lords, if it is a case that a kingpin wanted someone murdered. So when it comes to conspiracy, my lords, there are 2 ways in which conspiracy is established. One is, my lords, it could be a direct evidence insofar as conspiracy is concerned. Now, by direct evidence, my lords, we would say if a group of persons are sitting somewhere and conspiring, and that is witnessed by certain persons seeing them conspiring and hearing the act of conspiracy, that is where we say it's a case of direct evidence for this conspiracy concerned. Now, in many cases, we do have such circumstances, my lords, where independent witnesses would see the set of persons going to a room and would also hear what they're talking in terms of conspiracy. Those are cases of direct evidence of conspiracy. But also, my lords, as it's seen, certain conspiracies could be in secrecy. Now, if conspiracies are hatched in secrecy, it does not mean, my lords, there would be no evidence at all. There would be circumstantial evidence that are necessary to even bring in the aspect of conspiracy through circumstances. Now, a typical scenario, my lords, that we get of circumstances is if a person has seen these 5 persons getting into a room at a point of time, and later seeing them come out of that room at a later point of time. He might not have heard or seen what exactly has taken place there. So it becomes an indirect evidence insofar as that conspiracy is concerned. Last he's seen these 5 people going in, later he has seen them coming out. So inference that would be drawn is, look, it could be a case of conspiracy. This is how, my lords, we look at an indirect evidence in support of the aspect of conspiracy. Now here, my lords, a mere acquaintance between certain persons would not come under the ambit of saying there's conspiracy merely because the 2 of them travel together. In our case, my lords, one of the strongest circumstances as per the order below that we find is, my lords, in the month of February, that's precisely 11 to 2025, A1 had gone to Prayagraj along with A5. A5 is a petitioner herein. Now, this was on 11/2/2025. My lords, incident, my lords would recollect, is on 15/7/2025.
15/7/2025.
After 5 months from the so-called visit to Prayagraj on 11/2/2025. So, my lords, at best, they also say, my lords, this A1 was in the birthday party of A5, birthday celebration of A5, the MLA's birthday celebration. A1 was also there in that celebration. That was on 4/2/2025. So, drawing upon acquaintance between persons, my lords, in my respectful submission, the inference to say that it constitutes a conspiracy, that may not be right, my lords. Five-months gap between the traveling and the incident in question. So, in my respectful submission, the second element when we come to circumstantial evidence is the aspect of conspiracy, my lords. The third element would be, my lords, a preparation to commit the crime. Now, my lords, when it comes to preparation, there would be various aspects of the preparation. One could be, my lords, with regard to purchase of weapons. That is one form of preparation that takes place for committing crime. Purchase of certain vehicles. The payments that are made to so-called supari killers, if they are supari killers. Transfer of funds for the purposes of the crime. The meeting with the actual assailants. The meeting with the actual assailants. A telephonic conversation between the dormant accused with the actual assailants. Now, these are all, my lords, what comes into the ambit of a preparation to commit a crime, my lords. The fourth element post this would be conduct. Now, conduct, my lords, will be in two parts. The conduct prior to the incident and the conduct post the incident. My lords, conduct could be, my lords, the accused all seen together immediately prior to the incident. Similarly, my lords, post the incident, if all the accused are seen together, that is also part of the conduct. One other aspect that can also be considered in conduct is, my lords, if there is going to be an alibi that he is not there but at a different point is his conduct at the time of the incident. This is a fourth essential element, my lords, in my respectful submission on circumstantial evidence. Fifth would be, my lords, an electronic evidence. My lords, electronic evidence could be in the form of CDRs of the accused that they were in constant touch immediately prior to the incident or immediately after the incident. Now, with that, my lords, electronic evidence, CCTV would be relevant. Any communication through any computer system would be relevant, my lords. So this is the fifth element, my lords, when it comes to circumstantial evidence, with the sixth being, is there an extrajudicial confession? My lords, should have come across the instances, my lords, where an accused after the commission of crime would narrate it to a third party. So that amounts to an extrajudicial confession, my lords. Whether on the investigation made, is there any extrajudicial confession given by any of the accused persons is one of the circumstances that will be looked into. Then, my lords, the seventh would be statement of co-accused. My lords, statement of a co-accused cannot be a substantive piece of evidence. There can't be a conviction based only on the statement of a co-accused. It at best is of corroborative value. So you should have other evidence in place, and added to the other evidence in place, if the statement of a co-accused implicates you, it helps in tilting the balance. Well, Section 30 of the Evidence Act makes the statement of co-accused admissible only to this extent, not a substantive piece of evidence. The eighth, recovery on the basis of voluntary statement of the accused. Section 27 of the Evidence Act. Now, arrest, whether there's an arrest or not, my lords, a statement recorded by an investigating officer which leads to the discovery of a fact. So now, my lords, if a statement given by the petitioner leads to any discovery of a fact which can be linked to the crime, that is admissible now in the chain of circumstantial evidence. Though that statement to the police officer is inadmissible, but what you discover under 27 is admissible. And the ninth aspect in my respectful submission is the forensic science reports. Now, forensic science, my lords, it could be in different forms. It could be fingerprints in the scene of occurrence, or it could also be, my lords, at times, if they have the voice recording of the accused, a person giving instruction through a telephonic media to another person, his voice sample then can be taken, sent to forensic to ascertain whether it is a person, this person or not. My lords, in my respectful submission, when a crime is committed, and especially when a crime of a heinous nature is committed, my lords, it would be the foremost responsibility of the investigating officer at an earliest point of time to gather these evidences. Because, my lords, we would always see the 24 hours post the crime is the most crucial time when it comes to the investigation. My lords, if this information is not gathered by an investigating officer at an earliest point of time, thereafter, my lords, for him to even look at linking people, that itself becomes a suspicion, my lords. Now, my lords, in our case, repeatedly, my lords, we have been pointing out that we want to cooperate with the investigation. Repeatedly, the court has been directing the investigating agency to continue with that investigation. And despite this, my lords, despite this, now when a charge sheet is filed, I am not arraigned as an accused, but a request is made for further time. Not once, my lords, not once, my lords, after CID takes over the investigation, they think it necessary to call me or have any statement of mine recorded. My lords, throughout our submissions, my lords, and even in our pleadings and the representations that we have given to authorities, we have been repeatedly pointing out there is political malice involved. I ought not to have even been arraigned as an accused, but have been arraigned as an accused. I want to cooperate with this investigation. Now, despite that, my lords, the CID, which conducts this investigation for 5 months, would not think it necessary to call me for any investigation. And now when a charge sheet is laid before the court, they would not even arraign me as an accused, but say, we want further time. My respectful submission, my lords, the only inference my respectful submission is, my lords, the only inference that can be drawn is the conduct of the investigating agency would substantiate my apprehension of political malice. My lords, in this backdrop, my lords, yesterday I did mention about my lord's directions when it comes to investigation. I'd rely on that, my lords. Sujit versus Superintendent of Police, where this honorable court was pleased to consider the need for speedy investigation and how investigation should be done in a time-bound manner. This was on an interlocutory application that the directions were given. My lords, the relevant portion, my lords had considered what is the cause for the delay in investigation at paragraph 19, my lords. Paragraph 19. Capital A, my lords. It's at page 6, I'm sorry, my lords. Page 6. 19. Causes and consequences of delay in investigation. A. Causes of delay in investigation. Roman number 1. Lack of bifurcation of duties and need for entrusting of investigation to specified and designated personnel. Could I just pause here for a minute, my lords? Now, in our case, entrustment of this investigation is given to a specialized agency like CID. So they can't even say that we had other duties to do and therefore we were not in a position to complete this investigation within a time-bound manner. Then, my lords, the other aspects there may not be of much relevance insofar as the cause for delay is concerned. The consequences may be noticed on the next page, page 8, my lords, consequences of delay in investigation. My lords, noticed section 167(2), if they are arrested, how statutory bail would come into play as a consequence of delay in investigation. It's at page 8, my lords, page 8. Then, my lords, post that legislative and judicial framework relating to speedy investigation. My lords, the court had noticed section 157, how the investigation begins. Section 167 where remands are done, Section 167(5), and most important is Section 173. Every investigation under Chapter 12 shall be completed without unnecessary delay. And then the police manual is also referred to, my lords. Post which, the guidelines which my lords was pleased to formulate, which we get at page 12, my lords, guidelines for speedy investigation. A time frame which is put for investigation. Roman number 1, offences may be categorized into petty offences, serious offences, and heinous offences. As regard petty offences, time limit of 60 days could be fixed for completion of investigation, which could be extended by the special judge magistrate upon request, assigning reasons for extension of time for investigation to be completed. As regards serious and heinous offences, time limit of 90 days could be stipulated with provisions to extend such time period upon request by the special judge magistrate upon reasons made out. Such an intervention may be necessary in the light of the approach of the apex court in the case of Abdul Rahman Antule versus R.S. Naik. Now, my lords, despite these guidelines being there, we somehow find, my lords, it does not seem to be followed at all. Here is a case, my lords, heinous offense, 90 days for completion of investigation. My lords, if the investigating officer wanted further time, my lords, as per these guidelines, he needs to bring it to the notice of the court and point out why he needs further time to do his investigation. In our case, my lords, 24/7 is the date when CID takes over investigation. 22/12 is when they file a charge sheet wherein I am not arraigned as an accused. 5 months. My lords may notice Roman number 2 thereafter in the same page, page 13. In the event the investigation is not completed within the time prescribed and superior officer is of the opinion that there is no justifiable reasons for completion of investigation, power can be exercised under 36 of the CRPC by the superior officer. The magistrate special court can invoke powers under 156(3) to ensure investigation is expeditious and pass appropriate direction where the investigation appears to be procrastinated to the prejudice of the complainant and would have the effect of derailing the investigation. The magistrate can, upon application filed or otherwise, seek report from the concerned authority as regard delay in investigation. When grievance relating to non-registration of that we are not concerned with, my lords. I will not trouble my lords with that. Then, my lords, please notice the last portion of it at paragraph 24, my lords. This honorable court wanted all the investigating officers to be aware of these guidelines that have been issued. Paragraph 24. The Registrar General, High Court of Karnataka, to send a copy of this order for necessary attention to the following to all concerned, my lords. The intention of this court was to ensure that there is speedy investigation done in any crime and a charge sheet is filed within the time stipulated there. So what would happen in our case is, my lords, after 5 months, when I have not been called, nothing has happened, charge sheet which is filed on 22/12, containing about 4,000 pages, my lords, 13 volumes, I am not arraigned as an accused. Now that would assume importance, my lords, because if I am not arraigned as an accused in the charge sheet, it means, my lords, in their investigation, they would have no material against me. Now, as soon as you bring to the notice of the court, insofar as these two accused, we would continue our investigation. My lords, we are coming into the realms of section 173, subsection 8. What is otherwise called as a supplementary charge sheet. My lords, under the old code, this power to file supplementary charge sheet was not there, my lords. It was only in the code of 1973, they thought it fit to give the power to the investigating officer to come up with a supplementary charge sheet. But my lords, that power has been given not in terms of trying to reinvestigate a case that is going on or trying to dig what was already there, but when any new evidence comes on record. Now, can I read section 173(8), my lords? The whole object of that insertion, my lords, in my respectful submission, whole object of that insertion is, my lords, where a charge sheet has been filed, say against A, my lords, as the murderer to the crime. Later, my lords, the investigating officer, he discovers that it was not A who has caused this crime, but it is B. Then he should not be helpless. It is to aid such situation, my lords, that we see under 173(8). Could I read 173(8), my lords? That's now equivalent to 193, but I'll read 173(8) itself. Nothing in this section shall be deemed to preclude further investigation in respect of an offence after a report under subsection 2 has been forwarded to the magistrate, and where upon such investigation, the officer in charge of the police station, this may be relevant, my lords, obtains further evidence, oral or documentary. He shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and the provisions of subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as they apply in relation to the report forwarded under subsection 2. Now, I will point out the law on that aspect, my lords. Two decisions, my lords, of relevance where they have dealt with the scope of section 173(8) vis-a-vis 173(2). First of the decisions, my lords,
And there's
is
one submission. I'm sorry, I don't understand, my lord. Are we arguing for a quashing or arguing for bail? The time limit your lordship has prescribed, and the Supreme Court recently also held that the argument also has to be, there's some time limit for argument.
well, it's
If
5
he's
months
asking
taken
quash-
for
no, if
investigation.
if
They
he's
don't
asking
file a
for-
charge sheet against
if he's
me.
asking for quashing,
What
fair
are
enough,
they
my lord, let them
speaking
argue.
about
But
time
this is-
limit?
I don't understand what is the relevancy of this argument
I will
here.
point out, my lords, what's the relevance of this argument? In 5 months, you don't file a charge sheet against me. Is it only to oppose my
I'll
anticipatory
justify
bail
why
that
you
you
have
don't
not filed
file a charge sheet?
We will justify. You made a
Then
point.
you will have
we
to
made a
wait
point
till our
that you have not filed a
submissions are
charge sheet. You
over,
have not
my
filed a
lords.
charge sheet. I'm not disputing
They
with you.
can't,
Filed a charge sheet.
interfere into
We
the
have not filed
argument
a
in
charge
this
sheet.
manner.
We came back 6 months ago, 5 months ago, saying that we need to custodial interrogation. You are not cooperating with the custodial interrogation, and then expect us to file a charge sheet. I'm sorry, my lord, I don't understand. If they're asking for quashing of petition, fair enough. This is a bail petition. Arguments are going on and on.
Yes. Yes.
Lords, just on a lighter note, my lords, can I just point out, in 5 months' time, my lords, they would not choose to file a charge sheet against me. 5 months. Now, when I'm making my submissions on that aspect of it, my lords, to say Is it a case of waste of judicial time, my lords, on this submission?
Yes, it is.
That he may
I
say, my
filed my
lords,
object-
he may say anything.
I filed my
lords,
my
they may say
application on
anything.
18th December,
Yes,
18th
my lords,
September.
they may say anything they want,
Asking
but when
for
the
custodial
time
interrogation.
comes, let them not interfere into our argument or our lines of presenting our argument.
Arguments on what?
My lords, he wouldn't even know what we are arguing on.
Yes,
Just
I'm
standing up and opposing. My lords, we will not get anywhere with this.
I'm
my lords.
unable to understand.
If his interference is
Probably
in this
I'm-
manner, we will not get anywhere with this.
I am not learned enough, but I'm unable to understand.
I'm unable to understand. You will have to wait for it. Wait for the submission
For
to be
next year,
completed.
for whole year, we are
You
going to
don't
argue.
even know what the
No, you don't
submission is.
understand. My application is on 18th September 2025.
Yes. Yes.
Very tough with this kind of interference, my lords, for us to.
No, I kept quiet, my lord. Many arguments are repeated, as if your lordship has never heard this petition. Your lordship has passed 2 orders on these petitions. Your lordship knows the facts.
Then we don't
And
even
I don't
have to argue
understand
an
how
anticipatory
bringing
bail.
back from.
We don't even have to argue it. If everything
I
is
am
known.
not saying we don't have to argue.
Then you will
but
have
I'm
to
saying
wait
that
your
please
turn,
don't
await
repeat.
your turn, await your
Only saying
turn.
please don't repeat.
You will get your turn.
Just wait. Yes.
Well, it's on this scope of saying how when a charge sheet is filed, you ought to array the accused on whom investigation has taken place. 2 judgments that I'm relying on. My lords, the first of the judgment. Yeah, give Vadivel. Just point out in Vadivel and then go to the other one. My lords, this is the case in K. Vadivel versus K. Shanti, 2024, SCC online SC 2643. My lords, relevant paragraphs are between paragraphs 27 to 38, all dealing with how an investigation should take place, how a charge sheet to be filed, under what circumstances you can take aid of 173(8). Very well. Sorry, my lords, I'll just point out that relevant portion. My lords, may for a minute have paragraph 32, my lords. 32 would be at page 8 of the judgment. Could I read 32, my lords? Ultimately, the contextual facts and attending circumstances have to be singularly evaluated and analyzed to decide the needfulness of further investigation or re-investigation to unravel the truth and mete out the justice to the parties. As noticed in Ramlal Narang, where fresh materials come into light which would implicate persons not previously accused or absolve persons already accused, or where it comes to the notice of the investigating agency that a person already accused of an offense has a good alibi, it may be the duty of the investigating agency to investigate the genuineness of the same and submit a report to the court. This is where, my lords, the concept of 173(8) comes. Not in the first instance, my lords, not in the first instance when you're filing a charge sheet, you choose to leave out certain persons to say we will continue investigation at our own leisure. That is not the essence of 173(8). Now, paragraph 33, my lords, 4th line in paragraph 33. There must be some reasonable basis that should trigger the application for further investigation so that the court is able to arrive at a satisfaction that ends of justice requires ordering or permitting of further investigation. My lords, Vinay Tyagi is quoted at paragraph 34. The further investigation part of it, which is extracted, I will not read it, my lords. Paragraph 41 of Vinay Tyagi. Then, my lords, 35, they say, it is essential to note that this court emphasized that though power to order further investigation is a significant power, it has to be exercised sparingly and in exceptional cases and to achieve the ends of justice. My lords, paragraph 38 at page 11. That was a case, my lords, an additional charge sheet was filed, and how court said we would not accept this additional charge sheet. We are convinced that ordering the additional charge sheet to be taken on record at this stage pursuant to further investigation will not be in accordance with law. It will be contrary to the settled principles as laid down by this court. We have also, to satisfy ourselves, examined the additional charge sheet placed before us. Then they go into the facts of it. So please notice, my lords, in a given situation, when an investigation into crime takes place, it's a duty of the investigating officer to complete his investigation within that time period. Now, my lords, the only inference that can be drawn, my lords, is that you would not complete your investigation. So at the time when an anticipatory bail is filed, you would say it is still being investigated against this person. Now, please notice the second judgment, my lords, in Hemendra Reddy's case. My lords, this is 2023-16 SEC 779 State through CBI versus Hemendra Reddy. My lords, paragraph 47. They fragment section 173.8, my lords, paragraph 47, my lords, that would be at page 27. Page 27 minutes. Section 173.8 CRPC may be fragmented or dissected as under: 1. Further investigation can be done in respect of an offence wherein report under 173.2 has been forwarded to a magistrate, and, my lords, 2 may be very relevant. During further investigation, the officer in charge has: A, to obtain further evidence, oral or documentary. That is the essence, my lords. Further evidence, oral or documentary. Paragraph 48. How, my lords, there should not be delay in investigation, we get here. Paragraph 48. Subsection 1 of section 173 CRPC provides that every investigation by a police shall be completed without unnecessary delay, and subsection 2 of 173 provides that as soon as such investigation is completed, the officer in charge of the police station shall forward to the magistrate empowered to take cognizance of the offence on a police report, a report in the form prescribed by the state government. Paragraph 50 deals with 8, my lords. Subsection 8 states that nothing in the section shall be deemed to preclude any further investigation in respect of an offence after a report has been forwarded under 2 to the magistrate. My lords, what is the prime consideration of this further investigation? My lords may notice paragraph 54, my lords. As observed in so and so, the prime consideration for further investigation is to arrive at the truth and do real and substantial justice. The hands of investigating agency for further investigation should not be tied down on grounds of mere delay. In other words, the mere fact that there's further delay in concluding the trial should not stand in the way of further investigation, if that would help the court in arriving at the truth and do real and substantial and effective justice. My lords, the position of law on further investigation, paragraph 56, all the judgments on further investigation is extracted, my lords. In that context, if paragraph 64 is noticed, my lords, Vinay Tyagi's case. 64. In Vinay Tyagi, it was held further investigation in terms of 173(8) can be made in a situation where the investigating officer obtains further oral or documentary evidence after the final report has been filed before the court. Please notice this, my lords. After you file a final report before the court, if you get any further oral or documentary evidence, comes this power under 173(8). Not to say, my lords, I will pick and choose against whom I will file my final report, and then I will fall back on the same investigation to array other accused. That is not the object of it at all. My lords, finally, in this citation, paragraph 75 at page 39. This court in K. Chandrasekhar, then my lords may skip about 5-6 lines, my lords, there, and notice the last sentence in paragraph 75. The court drew inspiration from the fact that subsection 8 clearly envisages that on completion of further investigation, the investigating agency has to forward to the magistrate a further report or reports and not fresh report or reports. So, my lords, even now, if they're going to be looking at filing a charge sheet against me, it is a fresh report. Regarding the further evidence obtained during such investigation. So, my lords, in my respectful submission on this aspect of a charge sheet being filed, minus my name, and merely reserving a liberty that we will continue our investigation against the petitioner, it will not come within the ambit of this further investigation at all. My lords, now I'll just point out, kindly notice my conduct throughout this entire proceedings, my lords. The conduct of the petitioner for the last 5 months from 15/7/2025 till date. The first aspect of the conduct would be, my lords, whenever the petitioner was called for investigation, he has participated. Second aspect, my lords, the petitioner's statement has been recorded on 2 occasions, 19/7/25 and 23/7/25. Third aspect, my lords, the grievance of the investigating agency, that is the CID, that the statement contains falsehood can never be a ground to deny bail. The grievance is, my lords, so statement contains falsehood. That can never be a ground for denial of bail. Fourth aspect is, my lords, post CID taking over of investigation on 24/7, not once has the petitioner been summoned or notices issued for the last 5 months. My lords, during all this period, right from when the 482 petition was filed till my lords orders on 19/12/2025, not once did the High Court interfere with the investigation. And during this period, my lords, when the matter was under consideration before the High Court, not a single request made seeking custodial interrogation for any point of time during then?
My application itself speaks.
Anyway,
18
you can
September
have your
2025.
answer
No,
to it.
factually incorrect.
If I'm wrong, you
No,
can
factually
answer it.
incorrect.
It's all right. All right.
Factually
All
incorrect.
right.
My application of 18 September 2025 speaks.
All right, my lords, that may also be noted. They filed an application on 18 September.
Yes.
My lords, during this period of 5 months, my lords, there's not a single allegation that the petitioner either interfered with the investigation or has tampered with any witness. My lords, the petitioner is the one who's repeatedly saying, I want to be part of the investigation, and has chosen to withdraw the 482 petition for being part of this investigation. Now, my lords, per contra, my lords, may I point out how the investigation has gone about? What is the conduct of the investigating agency vis-a-vis the conduct of the petitioner? My lords, without wanting to repeat, my lords, they didn't summon me. That would be number one. 7 days after taking over this investigation, the proposal given to invoke COCA. Ten days thereafter, the approval for this proposal given on 12/8/25. And as you pointed out, my lords, when this whole proceeding was on, even limited custody was never sought. I will point out, my lords, why that limited custody would be of relevance, because their whole grievance seems to be, we want custodial interrogation. I will point out that. Along with the three aspects of importance is, my lords, in the COCA approval order, no role attributed to the petitioner in relation to the present crime. In the 19 remand applications that were filed, my lords, no role attributed to the petitioner with this crime. My lords, that again runs on the line of those 9 circumstances, my lords, which I pointed out for circumstantial evidence. My lords, added to this, the application which they are now trying to point out repeatedly, the application is filed on the ground that I am not cooperating with the investigation. Now we come down to this aspect, my lords. The main aspect which they are trying to highlight repeatedly is, look, we are not getting custodial interrogation of the petitioner. Now, when it comes to custodial interrogation, my lords, I will point out how limited custodies can be given. One aspect, my lords, that straight away comes would be Article 20, Subarticle 3, my lords. A right to silence that an accused would have, the right against self-incrimination, and it says, my lords, no person can be forced to be a witness against himself. The question arises now, my lords. With this investigation being complete and a charge sheet being filed, at this stage, why the opposition to an anticipatory bail? And if it is the only interest of saying custodial interrogation, then Supreme Court Constitution bench, my lords, would hold custodial interrogation is possible as one of the conditions while granting anticipatory bail. My lords, two aspects. One aspect would be, my lords, whether there can be a consideration of an anticipatory bail in heinous offences. The second aspect would be, my lords, would the court be justified in directing limited custody as a condition if an anticipatory bail is considered favorably? My lords, can I pass on the memo of citations, my lords, on these two aspects? Yeah, Paramchand Thakur. My lords, the first set would be in heinous offences where the courts have considered grant of anticipatory bail, my lords. My lords, there in all 10 decisions, my lords, only the relevant portions that I'm going to point out, 3 of the Apex Court and 7 of our High Court, my lords. My lords, kindly notice the very first one, Barun Chand Thakur versus CBI. My lords, this was a murder of a 7-year-old child, my lords. High Court granted the anticipatory bail. Supreme Court would confirm it, my lords, and it was a CBI investigation. Only the relevant portion, my lords. My lords may notice paragraph 4 at page 3. Bombay High Court, which granted the anticipatory bail, my lords. Interim stay from arrest. Then, my lords, the matter goes up to the Supreme Court. My lords, paragraph 15 at page 8. Even about media covering incidents, this is what page 8, paragraph 15, my lords. Further, we cannot lose sight of the fact that this incident had received wide coverage in the media, both electronic and print. In fact, it can be said that there was a trial by media. Therefore, when the private respondents had directly approached the High Court for grant of anticipatory bail under 438, and that too when the High Court had concurrent jurisdiction, we cannot find any fault with the action of the private respondent. Then, my lords, paragraph 18 at page 10. Please notice the conditions that are imposed, my lords. Paragraph 18, page 10. What is extracted? As a result of my above discussion, I find merit in both the petitions. Conditions may be noticed, my lords, that the petitioner shall make themselves available for interrogation. Most relevant would be this, my lords, by the investigating agency as and when required. That the petitioner shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case, facts of the accusation against them, so as to dissuade him from disclosing such facts. He shall not leave India. He shall seek regular bail on presentation of challan in court. That was what was the interim which has been followed in the final order. My lords, page 11, 2021 15 SEC 588. Page 11, my lords. Sumit Singh Saini versus State of Punjab. My lords, petitioner is a retired DGP, my lords. It was a case of a custodial death. Allegation was that it was at the instance of the petitioner that the custodial death took place. In that case, however, my lords, there was various departmental inquiries and other aspects that took place. And finally, when the petitioner was arraigned as an accused, it was with a substantial delay. The relevant portion, my lords, it was a case of 302. My lords should notice paragraph 4, how section 302 was added. Paragraph 5, my lords, High Court rejecting the anticipatory bail. And paragraph 7.1 may be noticed, my lords. What was the contention? It is vehemently submitted that the present FIR is filed with a malified intention to harass the appellant and at the instance of the present party in power in the state. Then, my lords, the court at paragraph 9, page 16, third line, at the outset, it's required to be noted that in the present appeal, the only question which is required to be considered is whether the appellant is entitled to anticipatory bail under 438. As I said, my lords, there was a lot of departmental inquiry. After about 29 years, he comes to be arraigned as an accused, my lords. So that was taken note of. And my lords, at paragraph 13, they point out he has retired as the Director General of Police, paragraph 13. And paragraph 14 is the grant of anticipatory bail. And always, my lords, the condition will be you have to cooperate with the investigation. We find that again here at paragraph 14, last but 3 lines, my lords. The last judgment of the Apex Court, my lords, 2022-13 SCC 246, page 18, Sufia versus CBI, page 18. My lords, this again is a 302 case. Initially, my lords, High Court granted an interim anticipatory bail. Subsequently, my lords, the High Court rejects it. The matter is taken up to the Supreme Court and Supreme Court grants anticipatory bail. My lords, the relevant portion please notice, my lords, paragraph 7 at page 21. Very specifically, my lords, they said custodial interrogation required, so anticipatory bail should not be granted. Shri so-and-so, the learned Additional Solicitor General of India, urged that this is a case of serious offence punishable under section 302 IPC and therefore custodial interrogation of the appellant is necessary. Relying upon statements of witnesses recorded under 164, he urged that looking into the seriousness of the allegation, the appellant does not deserve the protection of pre-arrest bail. He submitted that merely because there is some delay in recording statement of witnesses, the appellant cannot be protected considering the seriousness of the offence. Then, my lords, paragraph 10, considering the peculiar facts of the case, we are of the view that the appellant deserves to be granted pre-arrest bail. However, the appellant will have to fully cooperate with the respondent CBI for investigation and will have to remain present for investigation as and when called upon by the investigating officer. Again, in paragraph 11, my lords, the 4th line, the appellant shall fully cooperate with the investigation and shall remain present for investigation as and when called upon by the respondent CBI. We make it clear that the pre-arrest bail granted to the appellant is liable to be cancelled if it is found that the appellant is not cooperating with the investigation. My lords, similarly, our court coordinate benches had occasions to deal with anticipatory bail for offences of murder. My lords may have page 40, my lords, the first of the judgments dated 23rd April 2014, which is a case of murder, which we get at page 41. 302 is the offence, my lords, page 41. And at paragraph 5, my lords, the petitions allowed. Page 43. 41 it starts, 43, correct? 43, paragraph 5. Just cross check, no?
490
Sorry. My lords, my apology, my lords. Page 40. I'm sorry, my lords. My apology. Page 40, 23rd April 2014. Some mistake. Mix ಆಗಿದೆ. My lords, I'm sorry. All starts from page 22 in that. Is it going to another one? 40 is going to a different judgment.
No, the same judgment, sir.
It's at page 22, I think page dish. My lords, page 22, at page 23, 302 may be noticed, my lords. And then the grant of the bail, my lords should get that at paragraph 5, anticipatory bail granted, paragraph 5. The next judgment, my lords, page 27. My lords may notice at page 28, anticipatory bail, offence is 302, my lords. And on considering the various aspects of the case, the order, relevant portion of the order is at page 40. My lords, another coordinate bench, page 41, Mallamma versus State. The offences, my lords, initially it was 307, but my lords may notice page 43, 6th paragraph, alteration to 302.
Yes.
Again, my lords, case of anticipatory bail. Page 45, 31st January 2024. My lords would get the offence at page 46, 302, the consideration of the anticipatory bail. The relevant portion of the order is at page 52, my lords. So, my lords, in all these matters, the conditions may be noticed, my lords. Even in this, the second condition may be noticed, my lords, at page 52. The petitioner shall regularly appear before the investigating officer as and when called for. My kindly notice, my lords, 4 at page 53 condition. This is for the purpose of section 27, my lords. Thereafter, my lords, page 54, 11th January 2024. The offence at the bottom of that page, my lords, 302, right at the bottom. And the grant of this anticipatory bail is at page 58. There the matter was pending before the trial court, my lord. So the condition we get at page 59, regular appearance before the trial court. And at page 60, the fourth condition, my lords, cooperate with the investigating officer for the purpose of investigation in the case. My lords, page 61, another coordinate bench. Again, the offense here is 302 at page 62, third line at page 62. And the grant of anticipatory bail is at page 66. Again, condition C, my lords. At page 67, condition C. My lords, page 68, 20th December 2024. Offense we get at the bottom of that page 302. Pouring kerosene and lighting her on fire, my lords. That was the allegation. And the grant is at page 72. Again, condition 3, my lords, cooperation with the police for investigation. My lords, the last decision there is at page 74, High Court at Bombay, my lords. The grant, we would get it at page 80, my lords. My lords, these are decisions that deal with grant of anticipatory bail in heinous offences. On that second aspect which I pointed out, my lords, the power of the court to direct limited custody as a condition for grant of anticipatory bail. My lords, I'm sorry, citations are leave. Page 59, Bombay citations, 79, page 79. My lords should notice paragraph 10, my lords. Since the material, like in our case, my lords, I'm not arraigned as an accused as yet. Since the material in the charge sheet falls short of establishing a connect between the applicant and death of so-and-so, who was assaulted by 3 assailants, and the prosecution accused the appellant of the conspiracy, there in no way has surfaced from the charge sheet filed against the co-accused, the applicant deserves protection from arrest. He shall report to the police station, and depending upon the outcome of the investigation, it would be decided whether his custodial interrogation is necessary or not. Merely because the offense involved is under section 302 of IPC, it is not imperative for his custodial interrogation, and an apprehension of the applicant that he has reasons to believe that he may be arrested is sufficient to invoke the provisions of 438 of CRPC. And considering the fact incident has taken place some 3 years back, and materials compiled in the charge sheet against other accused reflects a limited role on the applicant, at this stage he deserves protection from arrest. My lords, on the second aspect, my lords, where I said in an anticipatory bail, can there be a condition insofar as custodial interrogation is? My lords, this point was answered by the constitutional bench, my lords, in the case of Gurbakh Singh Sibia versus State of Punjab.
How much more time will take?
My lords, this portion that I'll point out on judgment, and I'll only show the trial court's order, my lords. The whole reasoning appears to be custodial interrogation. for the rejection of the anticipated bill. That I intend showing, because the trial court, my lords, would fall back on my lord's observation and then say, because it is custodial interrogation, you're not entitled to anticipate bill. I probably, my lords, about 20 minutes, my lords.
We'll continue tomorrow.
Please, ma'am.
In the pre-lunch session.
Please, ma'am.
Release tomorrow. Arguments of senior counsel for the petitioner remains inconclusive. Jagdish, today before the academy, I had a class for the trainee judicial officers, and the topic was art of listening. So I didn't want to be untrue to what the sermon I've given. I have strategies also. So I've stated that suppose there is a disconnect. Now suppose you find, sometimes we do find that the lawyer is going on a tangent. Suppose the judge feels. Then I've advised them, you just go through the records mentally and be in advance. So then afterwards you can intervene. And anyhow, that's one of my qualities. Thank you. I didn't note the name.
Serial number 88.
ನಿಮ್ದು ಯಾವ್ದು ಸರ್?
88.
88.
ನರೇಂದ್ರ ಗೌಡ. ಸರ್, ಮಂಡೇ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್.
88
ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 47.
93 ಸರ್.
ಸಾಹೇಬ್ರೆ
ಯಾವ್ದು? ಅಯ್ಯೇ ಹಾಕಿತ್ತಲ್ಲ ಸರ್. ಅಯ್ಯೇ ಹಾಕಿತ್ತು. ಯಾವ್ದು ಸರ್? 73. ಮುಂಚೆ ಅಲ್ಲ
ಸೀರಿಯಲ್ ನಂಬರ್ 47. ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಒಂಚೂರು ಸರ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ
ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 47.
47 ಸರ್, ಬೆಳಗ್ಗೆ ಐತಲ್ಲ
47 ಆಗಿತ್ತು.
ಆಗಿದೆ ಅದನ್ನ ಒಂದು ಡೇಟ್ ಕವರ್ ಸರ್. ಸೆಕೆಂಡ್
ಸ್ವಲ್ಪ ಸೋಮವಾರ ಕೊಡಿ ಸರ್. 47 ಮಂಡೇ.
22 ಸರ್.
22 ನಾ ಲೇಟ್ ಆಯ್ತು ಸರ್.
67.
ಸೀರಿಯಲ್ ನಂಬರ್ 33.
Serial number 67.
67.
67, 77, 80, 84 ಎಲ್ಲ ಕವರ್ಡ್ ಇದೆ.
ಎಲ್ಲ ನೆಟ್ ನೋಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಬಿ ಗ್ರೂಪ್ಸ್ ಎಲ್ಲ ಇದ್ರೆ ಏನಿಲ್ಲ.
ಡೇಟ್ ಕೊಟ್ಬಿಡಿ.
ಬಿ ಗ್ರೂಪ್ಸ್ ಎಲ್ಲ ಇಲ್ಲ.
ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಹಾಕ್ಬಿಟ್ರೆ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ ಸರ್. ಅದು ಕವರ್ಡ್ ಇದೆ, ಅನೆಕ್ಟೆಡ್ ಮಾಡಿದ್ದೀವಿ. 67, 77, 80, 84.
67, 77, 80,
84. 4 ಮ್ಯಾಟ್ರನು ಅದು ಕವರ್ಡ್ ಇದೆ ಸರ್. ಎಲ್ಲ ಅನೆಕ್ಸ್ ಮಾಡಿದ್ದೀನಿ, ಬಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ. ಯಾವತ್ತು ಸರ್?
67, 77, 84, 88,
80 ಮತ್ತೆ 84. 80, 84 ಯಾವತ್ತು ಬರುತ್ತೆ ಸರ್? ಯಾವತ್ತು ಬರುತ್ತೆ ಸರ್?
Serial number 33. Sir, serial number 33. ಸರ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಮಂಡ್ಯ ಆಗ್ತೀರಾ ಸರ್?
Court of sir.
Sir, 78 140, sir.